I may be permitted to make a mention, Lord.
Yes, yes, yes.
This is also the third occasion I'm making a mention. RSA 202/23. My lords, the execution proceeding can wind up anytime.
Permission to make a mention, my lord.
Lordship.
The appellant is in jail custody since 5/6/2014. The appellant was convicted on
2014.
14.
Who
The
is
CRL 26 of
It's a
2016.
criminal appeal.
Sorry.
It's a criminal appeal.
Yes, sir.
Why
Before bail was earlier rejected by this honorable court.
Also one TADA bail matter.
Case admission RSA.
Yeah?
Case admission RSA.
Yeah. Yes.
Pardon, my lord. My lord, this is an Anganwadi case. I filed a memo already. Lord, the date was fixed to November 2022 after notice matter. And it has not yet come.
What? You have filed a memo today?
I've given it to.
Yes.
Grateful.
Supplementary list item number 1 for judgment. For the foregoing reasons, therefore, this court holds that in view of the provision under section 36 capital A of the Amendment Act, the RSD executed by defendant numbers 2 to 4 in favor of defendant number 1 is valid. Accordingly, the impugned judgment and decree are set aside. The suit of the plaintiff is dismissed. No other order could have been passed. Item number 2 for judgment. In another case, I have added this as a substantial question of law. In another case.
Here also your lordship added.
Added, but I did not know about this. Only after you referred to that amended provision. Because this has come in between.
Yes, my lord.
In 23 it has come. And I was not dealing with these matters, so naturally it has escaped my notice. And we are not supposed to keep track of all amendments.
It's not humanly possible.
Yes. But had I been in the district judiciary, these matters would have come up.
That there your lordship had only that civil and here variety of matters.
Yes. Yes, item 2. Item number 2. Resultantly, the writ application is allowed. The impugned order under Annex 12 is hereby quashed. The opposite party number 3 is directed to issue order of appointment in favor of the petitioner on a regular basis without any further delay, and in any case not later than 2 months from the date of production of certified copy of this order by the petitioner. Item number 3 for judgment. In the result, the appeal is allowed. The impugned judgment and decree passed by the first appellate court is hereby set aside. The judgment and decree passed by the trial court is hereby confirmed. There shall be no order as to cost. Item number 4 to be mentioned. To be mentioned, yes. No. I just wanted to add one more substantial question of law. We have missed it. You have argued it, but somehow it has not been specifically framed. Let me show it to you. While preparing judgment, it came to my notice. You see, originally, only one substantial question of law was framed. Yes. And that is 2A. Correct? Right. But 2A is see, खाली substitution part टा रह गया आरा part टा जोड़ा argument ही से रहे. So I think D will be
again right of user entitlement to the property.
2 distinct propositions. So I think that will cover everything.
Yes.
This matter has been listed under the heading to be mentioned as while preparing for judgment. It came to light that one of the central issues involved in the list has not been specifically framed as a substantial question of law, even though the parties had argued at length. Stop. As such, on consent of the parties, is an additional substantial question of law. The following additional substantial question of law is framed. D, capital D. Yes, Mr. Mahathi. So that was, while preparing for judgment, I found that has not been there. Only that substitution part is there. So not necessary, but still let us frame it up.
Yes.
Heard further arguments on the substantial question of law, additional substantial question of law framed today. Stop. Hearing concluded, judgment reserved.
Item number 5, fresh admission.
It was not pointed out by any of the parties. You have, or both of you have argued at length on that. The right of user and right of ownership, they are distinct. No, you have pointed out that the court has held of this, the first appellate court. I distinctly remember, but that
That is not the substantial.
see, substantial question or lot of substitution part rahigala. While preparing, I found I ran into difficulty. All right.
Item number 5.
Item 5, my lord. This TRPC may kindly come along with another TRPC number 142 of 2020.
142. So let's this matter next week along with TRPC.
Yes.
TRPC number 142 of 2024 next week. Next week to koi si hoga? Yes.
Item number 6.
Item 6, pass over. Pass over. Item 7.
Item number 7.
May I please, Lord Suman? Here the matter related to appointment of Jogana Sahayaka in Malijubang Gram Panchayat under Lanjigara block. And without cancelling the first advertisement, even though the collector has directed to expedite the selection process and report complex within 1 month, and without obeying that, now in 2023, under Annex 9, another advertisement is issued for the post of Jogana Sahayaka in Malijubang Gram
So in
Panchayat.
2014, one advertisement was issued.
Annex 1.
You were an applicant.
Yes.
Then what happened?
And when that has not been finalized, I have reprinted under Annex 4, and thereafter under Annex 5, I have filed a case before this Honorable Court, where the Honorable High Court directed to the direction to the collector to dispose of my reprint.
Yes. Then what happened?
And basing on that, under Annex 6, collect passed the order page 31. The operative person is also kind of against page 32. Considering the above following facts in course of hearing and with regard to the submission made by the petitioner and the OP, this court concludes that though the writ petition has been filed before the Honorable High Court of Orissa, no stay order in the selection process for the post of Jogana Sahayaka and Expert of Malijubang GP has been received as yet. Further, the post of Jogana Sahayaka in the said GP is lying vacant since long. After careful consideration and for the interest of general public, this court direct the BDO Lanjigara to expedite the selection process for the post of Jogana Sahayaka on receipt of this order within a period of 1 month. Thereafter, no action. When again I had approached this Honorable Court under Annex 7 months, and thereafter this Honorable Court on page 36, in view of the matter, this writ should stand disposal with the observation that in the event the petition would move before the open number 2 as to non-implementation of his order dated 29/3/2023 at the level of the open number 3, he would do well to immediately take up the matter in doing full in the matter of compliance of the earlier order.
Okay. There was no direction by the collector for fresh advertisement.
No.
He said that to finalize the selection process.
Yes. But without this, obeying that order now under Annex 9 page
Correct.
41.
All right, take notice.
Now the already selection euros. I filed a miscase. And in the advertisement, one criteria should be given that those who are salesmen in that people, he should be given preference. I have given the experience certificate, but that has not been.
Take your
Annex 9 is the fresh advertisement.
yes.
That is 7/7/2023.
1 year has gone by.
And my lord, apart from that, I think my lord, the petitioner had also participated. But lordship may come to Annex 11 series, my lord.
Yes.
It is at page number 44, my lord. Thereafter, my lord, the details of the eligible list and the reject list that has been submitted. Now, he has impugned this order, my lord, Annex 12, page number 47. That is 2/7/2024. Lordship may come to that. I will take the notice, madam. But with respect to the impugnment, that is what I'm
But
looking at.
no appointment has been issued. The BDO has directed the collector for approval. That with regard to the preference category, that they have not taken into
This
account.
is the position of the petitioner to get an appointment, my lord. This is the allegation against him.
That has been sufficed in Annex 30. They have stated that all the PDS quota we have received from the petitioner also.
And that is a different matter.
So,
So you are an unsuccessful candidate in the final merit list.
yes, in the final merit list, my
No,
lord.
no, in the merit list, first one now, 10, serial number 10, page 45, right?
Then final merit list.
Final merit list is at page 40.
But final
This is
merit
what, my lord,
list, they have not taken into account the preference category. Only basing on the
You are challenging the selection.
selection, yes.
That is
Without cancelling the first advertisement, no harm.
Only in first advertisement, it is no longer open to you to make that submission because you participated in the second advertisement without challenging it at that moment.
No, no, first advertisement is the collector directed to expedite matter.
No, true. But when the second advertisement was published on July 2023, you should have immediately come to the court saying that this is not the purport of the order of the collector. The collector said that you complete the selection process. You should have come to the court at that point of time, having participated, and now you cannot turn around and challenge it. You can challenge the merit list. That's a different matter. Anyway, Sri S.N. Patnaik Learned AG accepts notice on behalf of all the opposite parties.
Yes.
He shall obtain instructions and if necessary file a counter.
Yes.
Place this matter
9th August.
on 23rd August.
Yes.
IRA notice as above. That's all.
They have not yet issued any order of appointment the selected candidate.
So you have not been selected.
No, based on the career market, the preference category, they have not taken into account. Your lordship, for a moment, kindly have place 45.
Anyway, we'll say it will be subject to
any
appointment made.
Yes.
Place 45.
Any appointment made pursuant to the final merit list
Annexure 12 matter.
enclosed as Annexure 12
Yes.
shall be subject to the result of this writ application. Yes.
Item number 8.
Item 8. Item 8.
That matter. The salary, advertised salary has not been given to me. That is the crux of the matter. Once they have promised to pay me by virtue of the advertisement,
What was the last order?
Previously, my lord, Annexure 6, my lord, the rejection order was not under challenge.
Oh, so now
We filed one amendment petition
you have filed an amendment, it has been allowed.
and it has been allowed and consolidated writ petition.
So Annexure 6 is under challenge.
yes, it has been set into right law. It is by virtue of the amendment, the
Yes.
lordship has pleased to grant.
Yes. Let us complete it.
Yes.
Let us complete it. Yes, place it. How is it wrong?
Lord, the advertisement clearly encapsulates that the persons selected should be given the advertised salary. And in person thereto, the petitioner have been appointed. But that so far the disbursement of salary as per the condition mentioned advertisement.
Mr. Das, here is a catch.
Fine.
এটা তো দেখা যাଉନି ଯାହା ବି ହଉ ଆପଣ ଗୋଟେ ପଢିଲେ କଣ ହବ ଆପଣ ଗୋଟେ ଗୋଟେ ଏକ୍ସଟ୍ରା ଗୋଟେ ଏଲିଜିବଲ କପିଟେ ଦେଲେନି
Type କରି
ଯୋଗ୍ୟତା ହେଲା ବ୍ଲକ ସାଧନ କେନ୍ଦ୍ର ସଂଯୋଜକ ସ୍ନାତକ ଡିଗ୍ରୀ ଇତ୍ୟାଦି ତା ବାକି ପଡିବନି
payment of salary.
ପ୍ରାର୍ଥୀ ମାନଙ୍କର ଚୟନ ଆବେଦନକାରୀ ମାନଙ୍କ ମଧ୍ୟରୁ ଉପଯୁକ୍ତ ବ୍ୟକ୍ତିଙ୍କୁ ଏହି ପଦବୀ ପାଇଁ ବାଛିବା ଉଦ୍ଦେଶ୍ୟରେ ନିର୍ଦ୍ଧାରିତ ପରୀକ୍ଷା କରାଯିବ ଲିଖିତ ପରୀକ୍ଷା ଦଳଗତ ଆଲୋଚନା ପରୀକ୍ଷା ଓ ସମସ୍ୟା ଆଧାରିତ ଆଲୋଚନା. Did you attend all these things?
Yes, I have been duly selected. I am claiming the Nirdharita Dharma. My lord, the Odia is beg your lordship's pardon. There's been hazy. There 1700 to 3200 taka. That is the advertised salary. So,
But this was in 2000?
yes,
केवे ହେଲା ଏଟା?
advertisement of the
1998 ରେ 1998 ତ କଣ?
19.
You never challenged it.
Yes, we have challenged before this Hon'Ble Court. This Hon'Ble Court remitted matter back, which emanates the orders Annexure 6 below.
When did you challenge it?
A writ application.
2003.
Then that emanates the order Annexure 6 below.
Let us see the order.
Around there.
Kindly place the third paragraph of the impugned order.
If you order of that, may I read that? While disposed of the writ petition that.
No, third paragraph.
Third part. That the petitioner, Sri Somanath Ram, was initially appointed as a primary school teacher in level V elementary cadre on the RS scheme in Keonjhar district and joined in service on 28/7/1988. While continuing as such, an advertisement was published for the post of BRCC under SSA program by the state project director UPEPA on 23 December 1997. As per the advertisement, the petitioner Sri Ram was applied for the post of BRCC and deployed as BRCC by the DPP Keonjhar by order number such and such 16/4/98. The stipulation was given in that appointment order that the candidate was deployed with his own scale of pay with usual DA and other allowances as admissible by the government. That the appointment order dated such and such did not prescribe scale of pay rupees 1,700 to 3,200 to the petitioner. That appointment of the petitioner was temporary basis on foreign service term and condition because the post of BRCC is under DPP project. That the petitioner Sri Ram has accepted the said order of DPC Keonjhar and joined as BRCC in Sharpur block. Now the claim of the petitioner Sri Ram in higher scale of pay rupees such and such is not acceptable on the ground that such and such. So my humble submission, it is totally in contrast to the advertisement. This has been brought into the order which is not in consonance with the advertisement. Therefore, Lord, any departure to the condition of the advertisement may not be.
But you never challenged Annexure 2.
Annexure 2. Appointment of that, I challenged before the earlier petition relating to advertised salary. The matter was remitted back. So, the everything has been merged into the order of the earlier.
No adjudication on merits was done. Simply, you were granted liberty to.
Disbursement of advertised salary.
So when was that filed? When was that? When was the writ application filed? In 2003.
Yes.
The appointment order is of the year 1998. 5 years later, you suddenly wake up from your slumber and say that I should get the.
No, my lord. I was pursuing with the authority that pay me the advertised salary. My lord, it is a recurring cause of action.
No.
My lord.
Repeated representation, multiple representations on the same same issue without evoking any response from the authorities will never extend the period of limitation. That is the settled position of law.
To the authority.
So for that, you moved the authority. Within a reasonable time, if the authority did not take any action, you should have come back. How many? No.
We have challenged that order.
No, I find no reason. No.
Payment of non-payment of.
Sorry, Mr. Das. Sorry, I've heard you. I'm not convinced.
But apart from that, while not disbursing the advertised salary, they have been stopped by virtue of the advertisement. They promised to give me that.
No, that is true. That salary was meant for the newly appointed candidates. You were deputed or deployed rather on foreign service terms. In 1998, you never challenged it. You accepted it for 5 years. You came to the court. This court they passed an in-course order directing the authorities to consider your representation. But there was no adjudication on merits. So the issue is still open to be decided.
That issue has been, by humble submission, that issue having been remitted to the authority back, and authority considered, saying it is a foreign service, which is, as your lordship likely viewed, that it was conspicuously absent in the advertisement. Advertiser does not explicitly does not.
No. You are stopped. You have accepted it. By your conduct, you have accepted it. So by your conduct, you cannot now turn around.
But I have challenged that.
You have challenged it, true, but after 5 years. Your writ application was filed after 5 years.
That's true. But my humble submission.
Please, Mr. Das. It was always open to you not to join. It was a deployment. You were working as a private teacher in the elementary cadre. It was open to you to not to join. When
we objected, they said that your matter will be considered.
No.
So, my lord, consider. They have said Annexure 2, my lord. They have said consider. Consider means, my lord, they themselves keeps the matter in a.
Where is that letter? Where is that order that they will consider?
Annexure 2, my lord. My lord, please, may I beg lordship, pardon, my lord, to invite lord's kind attention, Annexure 2, page 14.
They simply say regarding higher scale of pay, view will be taken later on. Is the view they have taken?
They kept in boiling, my lord.
No.
They kept it, the opposite party kept the matter in boiling, my lord, by saying that we will consider lateral.
No. Yes, what do you say? What is your counter?
Our counter, my lord, we have stated, my lord, justifying that stand of annexure 6.
No, government has not filed. Because
Government is not.
It's a, in fact, my lord, counter has been filed by the OPEPA. And there they have stated, my lord, limited point, my lord.
It is said that no policy decision has been taken regarding payment of higher scale.
My lord, before issuing the appointment order, there was a decision, my lord, by the state project director, that is 16/3/1998, that whoever is going to be engaged on being deployed under foreign service terms and condition, they will only enjoy their own scale of pay, my lord, not the prescribed scale of pay, what it has been issued in the advertisement.
But it should have been mentioned in the advertisement.
But this is, my lord, issued on 16/3/1998.
Yes.
And accordingly, my lord, taking into consideration this particular aspect, when the engagement order was issued to the petitioner on the deploying him, my lord, as BRCC on foreign service terms and conditions, it was specifically indicated that he is going to enjoy his own scale of pay.
Yeah, that is true. That is true. But also it was also said that the decision relating to higher scale of pay will be taken later on.
My lord, that is 16/3/1990.
Yes, yes.
When the decision, my lord, this is only with respect to the pay scale. But at the time of issuing the engagement order,
yes,
as BRCC, no such stipulation, my lord. And my lord, he accepted the same and continued with that particular scale, my lord. And in the previous case also, he had never impugned these particular two documents. He has only claimed that particular salary. And in the year 2010, my lord, when it was remitted to the authority for consideration, they considered it and they passed it.
All right. Anything else?
yes, Asif knows that already. Promissory is because by virtue of advertisement, they have promised to me to pay that salary.
Yes, anything else? Which call?
234.
Yes?
234.
Yes. Please come to this mic. ताको कौन से टूट हुआ?
ठीक है सर.
आगे आप उठ जाओ. काली तो पहले से ही चेयर दी तरह पछपट लगे हो आर्गुइंग काउंसिल हैं और आर्गुइंग काउंसिल ओनली. कल माने आरो विक्रु सोमवार ठो जेंति लागि जिवो दी रंग चेयर आस्टर रेस्टोरेंट को. आगे कोन?
Joint all 2498 to 36/2003 reverted back. This scheme already abolished. It is as join kole foreign short and conditions as for the appointment order, no challenge at the time of joining. जो annexure 6 टाको सारे ଏବେ amendment कले, that is rejection petition.
Yes.
The question does not arise to higher scale of pay.
All right. Yes, Mr. Das, nothing. I'm not inclined. The petitioner has approached this court.
Point that they are stopped by virtue of the advertisement.
I'll take your point, but it will be dismissed. The petitioner has approached this court with the following prayer. The facts of the case are that an advertisement was issued on 23/12/1997 by the OSEPA authorities. OSEPA full form लिखी तब OSEPA लिखी है ना? At that time, the petitioner was working as a primary teacher. The petitioner was at the time was working as a primary school teacher in level V elementary cadre being appointed on rehabilitation assistance scheme in Keonjhar district since 28/7/1988. So he applied pursuant to the advertisement for being appointed as BRCC. Being selected, he was favored with an order of appointment issued on 16/4/1998, clearly stating that the appointment is purely the appointment is on foreign service terms and conditions by his parent department. Stop. The grievance of the petitioner is that the advertisement mentioned that the scale of pay of BRCC at rupees 1,700 to 3,200. It is the petitioner's grievance that despite such stipulation in the advertisement, the petitioner was paid the salary of his previous job. Stop. He approached this court in a writ application being WPC number 5898 of 2003. By order dated 17/5/2010, a division bench of this court, finding that a representation dated 6/1/2003 was pending before the Director Elementary Education, disposed of the writ application, directing the director to take a decision on the representation within a period of 3 months. Stop. The matter remained pending with the director and was ultimately disposed of by order dated 23/2/2013 in rejecting the claim of the petitioner, copy of which is enclosed as Annexure 6 and is impugned in the writ application. Where is your consolidated application, writ application?
Yes,
File corner? Consolidated. Anyway, counter affidavit has been filed by the district project coordinator SSA Keonjhar on behalf of opposite party numbers 2 to 4. It is stated that the petitioner was working as BRCC in the DPP Keonjhar from 16/4/1998 to 30/6/2003 till closure of the scheme. Stop. His appointment was by way of deputation on deputation from the parent department on foreign service terms and conditions. The petitioner, being a level 5 primary school teacher, was allowed to join on his own scale of pay. The petitioner also accepted the same. Stop. The petitioner has filed a rejoinder stating that in the letter dated 16/3/1998, and here also I can ask you, where did you get this letter from? How this is an internal communication? This is not a public document. 1998, issued by the special officer OSEPA to the district inspector of schools. It was clearly mentioned that a view shall be taken later with regard to higher scale of pay. Stop. Para heard Sri B.S. Das, learned counsel for the petitioner. Sri S.N. Patnaik, learned AGA for the state. And Sri, sir, you are Mr.
Yashwant Das,
Sri S.N. Das, learned counsel appearing for the
opposite 2, 3, 4.
opposite party numbers 2 to 4. Sri Das would argue that having specifically indicated, having specifically mentioned a particular salary in a particular pay scale in the advertisement, the authorities are stopped to pay a different scale to the petitioner. Moreover, the petitioner, despite joining, had been submitting representations to the authorities to grant him the advertised scale of pay, but the same was not considered. So he therefore approached this court in the earlier writ application, wherein the director was directed to take a final decision in the matter.
Under annexure 5, my representation pursuant
ଛାଡ଼ନ୍ତୁ ଦରକାର ନାହିଁ।
ସେଥିରେ ମୁଁ ଲେଖିଥିଲି ସବୁ କିଛି।
ଠିକ ଅଛି। Sri Das further submits that having that the post in question being advertised with a particular scale of pay, it is not open to the authorities to grant a different scale of pay. Stuff. As regards the so-called acceptance by the petitioner of the terms of appointment in the year 1998, Sri Das would argue that the petitioner, having repeatedly submitted representations and also approached this court within a reasonable time, no estoppel would lie. Para. Sri S.N. Patnaik, learned AG, would submit that the question of grant of higher scale of pay is a policy decision to be taken by the appropriate authorities. In the incident case, the petitioner accepted his deputation from his parent department on foreign service terms and conditions. He therefore cannot turn around to question the same at a belated stage. Para. Sri S.N. Das, learned counsel appearing for the OSEPA, while making similar arguments as the state counsel, further submits that that the scheme has been closed since 2003. The petitioner was deputed on foreign service conditions. He never questioned the appointment. After hearing the rival submissions and on going through the materials on record, this court finds that undoubtedly the pay scale of rupees 1700 to 3200 was indicated, was mentioned in the advertisement. A decision, however, appears to have been taken by the OSEPA that those applicants who have been selected as VRCC would be entitled to their own scale of pay plus DA, ADA, which they are drawing in the parent department. And further that, a decision regarding higher scale of pay would be taken later. Nothing has been placed on record to show as to whether any such decision was taken. Stop. Be that as it may, this court also finds that the appointment letter dated 16/4/1998 issued in favor of the petitioner was on the following terms. लिखित हूँ तो कोर्ट कर देगा Annex 3 series with his own scale of pay with his own as admissible term claim pending sanction of foreign service terms and conditions also. Stop. Thus,
Appointment order, next document is relief order, also containing the same stipulation. That with his own.
all right. Further, the petitioner also appears to have been relieved upon closure of the PEP with effect from
30th June. 30th June 2003.
36/2003,
3.
also on the same terms and conditions. Thus, this court finds that the petitioner, not being a fresh appointee, was deputed from his parent post on foreign service terms and conditions. It is true that the advertisement does not stipulate any such deputation, but then it is also to be considered that the petitioner accepted the terms of appointment without raising any objection or protest. 5 years down the line, he approached this court in the previous writ application, which was disposed of by an innocuous order, simply directing the director to take a final decision on the representation submitted by the petitioner. Stop. As such, there was no adjudication, and the point was left open. Stop. The result of the impugned order reveals that the petitioner's claim for higher scale of pay was rejected on the ground that he had accepted the temporary deployment as BRCC in his own scale of pay, and that he was never permanently appointed as BRCC. As such, his original scale of pay, as admissible to him, being a level 2 elementary cadre teacher, was maintained. Stop. This court finds nothing wrong in such decision, mainly because the deputation was a purely temporary affair. Intended for a limited period. Under such circumstances, it was only proper that he was continued on his own scale of pay. As otherwise, it would have led to complications in future had he been granted higher scale of pay. ହେଲା ଏ କଣ ଲେଖି complications after his reversion to his parent post, had he been granted the higher scale of pay in the temporary deputation. Stop. Moreover, the petitioner does not appear to have questioned the terms of such appointment at the relevant time and did so 5 years after the issuance of the same and at a time when the DPP, the scheme was already closed. Stop. This quote, thus from a conspectus of the discussion on facts, discussion made here and before, this court finds no merit in the writ application. Resultantly, which is therefore dismissed. Yes.
In one place, the lordship observed that level 2, it will be level 5.
नहीं ताका order लिखा जी level 2.
না level 2 মানে
level 5 টা original order it's लिखा जी level 2.
level 2
so we will गोटे काम से avoid कर दूं level टा काट दूं खाली primary school teacher कर दो तो गला
Yes.
से up to percent कर दीजिए
से primary school teacher है गला yes
concept your lordship
Aye.
the main concept because after 5 years he approach
तापर आ गोटे कथा जोटा
अब
struck me it's a temporary. So had you been given the higher scale of pay, you would have been deducted back. So it would have created now अपना reversion होला पर अपना parent scale को जाके हम already पैसा charge कर मत दियो तू सब तो अपन नेबे
I was discharging my
no Mr. Das come on this is on a lighter vein what are you saying
I don't know 9
yes Mr. Pratap so that matter
that matter I have filed a IA
for
amendment.
For what amendment?
So far I am challenging the order of the RTC. In the the IA has not been listed.
আসছে সারি দাও
এটা আসছে স্যার তাଙ୍କୁ ଗୋଟେ କପି ଆଜି ମୁଁ
ଫାଇଲ ଫ୍ରେଶ ରିଟ୍ ଆପ୍ଲିକେସନ
ନାଇଁ ମୁଁ ଡିସିସନ ଆଣିଛି ଆଜ୍ଞା
କଣ ଡିସିସନ ଆଣିଛ
ଆପଣଙ୍କର ଟୁ ଡିସିସନ ବିଫୋର ୟୋର ଲର୍ଡସିପ so far the facts are
no you can challenge it no it's not that you can't challenge it you can challenge it that is a law
fresh writ petition ହେଲେ ଟିକେ ପୁଣି ପଳେଇବ 10 ବର୍ଷ ଇଏ 13 ମସିହାରୁ ଆଜି 24 ମସିହା ତେଣୁ ମୁଁ ଗୋଟେ amendment ଫାଇଲ କରିଛି RDC ପାର୍ଟି କରି
have you served copy
ହଁ ମୁଁ just ସବୁ କପି ଦଉଛି next week ଆସ
RDC cannot be made a party no RDC cannot be made
ମୁଁ prayer ଟା change ହବ
it is his inquiry report of the state will defend state council will defend
ଆଜ୍ଞା ମୁଁ କପିଟା ସର୍ଭ କରୁଛି next week ଆସ
yes have you received copy all right IA 9148 of 2024 is an application for amendment copy of which has been served on the other side in court today place this matter next week
I don't know 10
Room number 10
In
my
this
lord
case,
your
my lord, in this case, after hearing at length, my lord, from the my lord,
to address the court as to the implication of the judgment passed by this court who is case in
Yes, Bindani case
next week, ratification.
But,
you want some
next week but I am also unable to collect that copy of the judgment
कौन who is case बिंदानी
Usi case
ये
Bindani
बाहर कर लीजिए
No, it's
But,
नहीं नहीं
नहीं
ଦେଉନାହାନ୍ତି,
ସେଠି
ମୁଁ ଏଠୁ ବାହାର କରିଛି
upload ହେଇନି
WPC
correct
11748 of 2003
11748 of 2003
disposed of date ଦେଖଉଛି କିନ୍ତୁ
ତାପରେ କଣ ଗୋଟେ ମିସ୍ କେସ୍ ବି ଫାଇଲ ହେଇଥିଲା ଆଇଏ ଗୋଟେ ଫାଇଲ ହେଇଥିଲା that was listed
shall we call for that record
that will be better
it will be better to call for the record see upload कौन पे हिने तो all right
2004 ରୁ ହେଇଛି ତ ସେଥିପାଇଁ କରିନଥିବ
it depends on whether it has been digitized or not something like that
yes
Learned State Council council for both parties submit that they have not been able to they have not been able to go through the judgment in judgment of this court in Hrusikesh Vindhani, as the same has not been uploaded in the official website. List this matter next week.
Yes.
Along with WPC number 11748 of 2003.
Next we got a date fixed.
Next week, next Friday. It will come on 26th. 26th is a holiday.
Holiday.
Holiday to the Foundation Day of the High Court.
26th July.
26th. 26th July is the Foundation Day of the High Court.
ସେ ତଳେ ଲେଖା ହେଇଛି କିନ୍ତୁ ଗ୍ରୀନ ଦିଆ ହେଇଛି
ଛୁଟି ହେଇନଥିବ ଏଥର
25th ରେ
ଆଉ 25th ହବନି he is not allowing ମୁଁ କଣ କରିବି he is the court master if he doesn't allow nothing will happen ଶୁକ୍ରବାର ତ ଅଛି ତ ଥାଉ ଦେଖିବା
ଆସିବନି ଯଦି ପୁଣି ରହିଯିବ ସେ ଆଉ
ରହିବ ଆସିବ କଣ ଏମିତି 2022
ହିୟରିଂ ସରି ଯାଇଛି ଅଲମୋଷ୍ଟ ସେ ଋଷିକେଶ ବିନ୍ଧାନି has no impact on my
since it is a working day it will come on that day definitely we'll see to it but because it's not holiday had it been holiday it would have been indicated in red yes item 11
May please. Petitioner challenging
Anganwadi
the order dated 24/8/2022, file annexure 1.
Mr. SN Mishra was opposing. Is not there today?
Here only two questions are there.
Yes.
The
Which is the impugned order?
Pardon, my lord?
Which is the impugned order?
Annexure 1, page 12, my lord.
Yes.
Wherein, my lords, on the very same first date, while my lord the matter was taken up by the my lord the ADM Jaspur, a time petition was filed by the present petitioner, seeking a time for giving the reply. It was not allowed. It violation of the natural justice, my lord. And number two, finding that the opinion number 6, having the resident of that area. This is a selection in the year 2007, my lords. At that time, she has submitted, my lord, the resident certificate, which is found to be not genuine by the competent authority. The present petitioner went on in an appeal, and the appellate court held that the resident certificate issued by the competent authority is not a genuine one. And that order was not challenged by the present opinion number 6, my lord. And so far, my lord, the third question is that the opinion number 6 has filed an application for appointment of the Anganwadi worker, stating therein that she was a destitute lady, my lords. But in the year 2007, no proceeding was initiated. Only she stated in her application, my lords. And in the year 2013, she managed to get a decree of divorce in the year 2013, my lords. This is the ground, your lordship, to be considered, my lords.
Replace the impugned order then.
My lords.
Please place the impugned order. I don't want annexure 1 though.
Annexure 1, my lord.
All right, please.
The respondent number 5 filed Bhaktilandama in favor of the advocate so and so, along with a time petition on the ground stated therein.
You are respondent number 5.
My lord.
All right.
Since the
So why appeal was filed by the opposite party number 6?
Opinion number 6, my lord.
Why was the appeal filed?
Because
Please tell me the facts first. There was an advertisement.
the fact advertisement not made by the competent authority. The present petitioner, opinion number 6, applied for that post, my lords. And the opinion number 6 was initially issued appointment in her favor. Challenging that, my lord, the present petitioner filed an appeal. And in that appeal, my lord, the petitioner was succeeded. According to my lord, the petitioner again, the opinion number 6 was disengaged and present petitioner engaged in that post, my lord. Subsequently, challenging that, my lords, a writ petition was filed here, my lord. And this honorable your lordship was limited back the matter to the competent authority to decide the appeal, my lord. And this is the order which was passed by the
Yes. Place it.
along with a time petition on the ground stated therein. Since the period for compliance of the order number so and so dated so and so in WPC number so and so has been stipulated within 4 weeks, the prayer for the time is not considered. This is the one aspect, my lord. Then, my lord, the instant case has been instituted as per kind order of the Honorable High Court of Orissa passed in WPC number so and so appellant Sobharani Rao, so and so, who has challenged the order in the dated 28/12/2016, passed it by the ADM Jaspur in AWW miscase number 5 of 2016.
The earlier writ application, whereby it is remitted.
My lord. Gone through the case records and documents as available in the case records, along with the order of the Honorable High Court passed in so and so, it is ascertained that the report submitted by the CDPO Dasratpur dated 24/10/2007 in the above writ petition, it is clear that the certificate submitted by the appellant was correct and she was a destitute lady. To that effect, my lords, your lordship may kindly see. Further, the affidavit filed by the Tahsildar Jaspur in the above writ, it is revealed that the miscase certificate number 3344/2007 dated 1/6/2007 relating to the residential certificate issued in favor of the Sobharani Rao is genuine, and it has been wrongly issued as miscase number 3348/2007 by the staff, which is a clerical error. In view of the fact discussed above, this court is inclined to hold that the selection of the appellant, that is Sobharani Rao, as an Anganwadi worker in so and so Anganwadi center, is genuine, and the order of the CDPO Jasapur is hereby being agreed by the order of learned Tahsildar Jaspur in miscase number 3348/2007. In response to the notice issued by the court, the respondent number 2 have appeared through our advocate, perused the case record, had gone through the contention of both the parties. On perusal of records, it is reveals that the respondent number 2 has submitted the residential certificate bearing registration number 3348/2007 during the scrutiny of the document for the purpose of the AWW in so and so. As she is the permanent residence of Bihipur, but the report of the Tahsildar Jajpur submitted by so and so, it is reveals that the miscase number 3348/2007 issued in favor of one Shraddhanjali Sahu, so and so. So it is admitted that the respondent number 2 has submitted a false certificate during the scrutiny. On the other hand, the respondent number 2 remained silent over all allegation of the appellant and slept over the matter. In view of the above facts, I am of the opinion that the respondent number 2 has committed an error by depositing false certificate during the scrutiny for the purpose of so and so. So this is my lord. This is that was my lord's cancelled, my lord. That cancellation order was not challenged by the opinion number 6 at point of time, my lord. Merely observation that due to clerical error, the certificate was issued. Right, wrongly, the certificate was issued, my lord, under miscellaneous certificate rules. It was challenged by the aggrieved party. And the appellate court held that, my lord, this is not genuine one. So my humble submission would be, my lord, that in absence of any documents required for the appointment of Anganwadi worker or wrong document, the application is incompleted one, my lord.
What is your counter affidavit?
My lord, the counter affidavit says, my lord, that with respect to the residential certificate, my lord, that it has already been clarified in the impugned order itself that it is a clerical error because the miscase number, it is 3348. In fact, my lord, it relates to somebody else. But the actual case number in respect of this, that Sobharani Rao, it is 3344. So since Tahsildar was also a party, and in the previous writ petition, my lord, he had filed a counter affidavit indicating that, my lord, it is 3344 and the certificate is genuine, the Tahsildar. So with respect to the residential certificate of 3344 number, my lord, with 33448, my lord, that has been issued by the authority. And now the authority subsequently admits that it is a clerical error. It should have been 3344.
So the order of the sub-collector should have been modified.
With respect to this annexed 2. My lord, all these things were taken into consideration at the time of earlier writ petition, my lord. Now, after the in the earlier writ petition, after taking into consideration all these points, when the matter was remitted once again to the authority for reconsideration, thereafter, my lord, this order was passed.
No, what I will do is, anything else you would like to submit?
My lord, another point, my lord.
Yes.
The question of destitute, my lord. Now we have clarified that part also in our counter. That considering for a moment, my lord, for the sake of argument, that she is not a destitute lady. Still then, my lord, she is a beneficiary. She will be a beneficiary if she is a destitute lady by adding 5 mark more, my lord, in the selection process. Ignoring that 5 mark even, that Shobharani Raut has secured more mark in the merit position in comparison to the incumbent Ranjabala Ras. That also we have indicated in our counter. If you are going to ignore that destitute certificate even. And with respect to residency certificate, when the competent authority, that is Tahsildar, admits that in shape of an affidavit for the Honorable Court, saying that it has been incorrectly issued and it is a error and the number is actually different.
Where is that earlier merit application?
My lord, that is not there, my lord, but if your lordship will come to.
I will call for the writ applications, both writ applications next week. And I have heard both of you, but Mr. Mishra is also not there. One more opportunity will be granted. What do you say? Yes, your lords. Please this matter and heard further arguments in part. Please this matter next week along with WPC number
2376.
No, 15899 of 2008 and WPC number 2376 of 2007.
Yes.
It will come next week, next Friday. Next. Item number 12.
Lordship, on the last occasion, further affidavit was served on the council. Lordship, to that they have filed one objection and they have.
Objection serving copy.
What are we? Last we order, okay. Order uploaded.
Lordship, on list is next week.
Just a moment. नहीं
Lordship, it was last listed in the year 2014 or 15.
Okay. You are referring to that order?
Yes, Lordship. They filed a counter. To that effect, we filed a rejoinder.
Yes.
Subsequently, we got the information and 2 other persons have been rehabilitated as per the land out scheme. Subsequently, we filed the RTA documents.
What is this matter?
Lordship, this matter relates to rehabilitation of land out scheme.
Why has it come to me? This
Lordship,
is not in my assignment. Isn't it? It is not in my assignment. Giri, हमको क्या इसका? I don't think this is my assignment. Okay. Am I assignment? Am I assignment? Place this matter before the assigned bench.
As per the orders passed by directions of the Honorable Court, my lord, they served me a copy on 28th of June 2024. I have sought instruction the matter. I had undertaken to file a reply. I need 7 days.
As paid for by learned counsel for the petitioner, let's this matter. On 2nd August.
2nd August. Yes, ma'am.
Reply if any be filed in the meantime.
Item number 14.
Now I filed a rejoinder. Kindly taken up Monday, Mr. B.N. Mahanti can argue this matter.
Yes.
B.N. Mahanti, Biranchinaran Mahanti argue this matter. Kindly taken up Monday. Just now.
You are filing rejoinder. Learned counsel for the petitioner files rejoinder in the court. Not Monday. Let's this matter next week. It will come on Friday.
କୁଆଡେ ପଳଉଛନ୍ତି senior।
କଣ କରିବା ଆମର ଲିଷ୍ଟ ଆପଣ ନୋ ନୋ
Officer, my lord. Just now I received.
Item number 15. May treasurers. Sir, my lord, petition is challenging the order dated 10/1/2017 regarding the enforcement to reconsideration of the grievance of the petitioner as per the direction passing WPC number 9226 of 2016 regarding disengagement of the petitioner's Sashikanta Mishra. Here in this case, my lord, under annexure 2, I have the disability given the disability certificate, page 18, my lord. From my lord district headquarters, my lord, hospital CORAM, 80% disability. Then I got appointment under annexure 3, my lord. Is selected and subsequent annexure 4, I was appointed as a
Sikha sahib.
Yes, my lord. Page 19 is the selection, my lord, order, my lord, annexure 3. Then my lord, annexure 4, got appointment and they only served for 2 years, my lord. And thereafter, they, my lord, issued for my lord,
Appellate Medical Board.
medical examination disability, my lord, further, my lord. And subsequently, I was, my lord, give some medical reason, I was unable to attend the medical examination. And thereafter, I was, my lord, terminated from the service, my lord. And thereafter, my lord, I have
Yes, yes, yes. Repeated opportunity दिया अपन appear कर लेना।
that therefore, my lord, I was disengaged. Subsequently, I approached before this Hon'Ble for reconsideration of my grievance, my lord. In the WPC number, my lord, yes, my lord. Then that was finally, my lord, under annexure 13, was rejected on the ground that I have, my lord, 4% of my lord disability, my lord. Then this Hon'Ble court, my lord, on 2/4/2019, lordship in this present order dated 2/4/2019, directed for examination before the special medical board constituted by the SCB Medical College Hospital. And thereafter, my lord, I was examined, my lord. And here, my lord, the report, I have 46%, my lord, my disability, my lord. And in similar case, my lord, another candidate, my lord, was also disengaged in 2012, my lord. Subsequently, my lord, this Hon'Ble court also directed for consideration of the grievance on the
Take instruction on this.
yes, ma'am. Instruction ground.
Learned counsel for the petitioner files the latest assessment of disability conducted by the Department of Department of ENT, SCB, MCH, Cuttack. A copy of the said certificate be handed over to Learned State Council, who shall take instructions.
I have given my
Instructions in this regard. Place this matter
9th August.
on 9th August.
Item 16.
On behalf of Mr. Das for optimal, pray for after recess, after lunch.
After lunch, my lord, I have a 2 o'clock matter fixed. Before court number 40. So I can't make myself available. So some other date, if it is possible.
Maybe 2nd August.
Second August?
My learned friend, Mr. Pradhan, is not the original lawyer.
No, he is making a request. On behalf of the lawyer.
So.
Who is to argue this matter?
Hello?
Who is to argue, Mr. Pradhan?
Mr. Joshua Das, my senior counsel.
So you give a date?
23-24
Teacher is over.
Sir, देबे आपको?
2 2 August.
2 August.
As
a request, sir, actually. So pursuant to the orders passed by this Honorable Court, my certificates were sent to the respective boards and universities for verification. I believe all the reports have come. So let them share the copies of those reports.
Yes, Mr. Das. If you have received the copies, then why don't you share?
In the meantime,
In the meantime, copies of instructions received by the State Council shall be shared with,
regarding verification of certificates.
regarding verification of certificates, shall be shared with the council for the other side.
Right.
That I have not checked up. I have got the records. जो देखो तो दे पाइए बस देबे को बोला.
पहले हम सुविधा हो एकातर सॉरी.
Yes.
Item 7.
Interim order to policy.
Interim order to continue.
Pass over the material also.
Pass over.
Order. Report is cast.
Item number 18.
Here I have tell us the order of the appellate authority. On the next 10. Before that, my lord, I would like to draw your lordship's attention to the circumstances. I've prepared a
Yes.
How this appeal was emerged, my lord. The lordship will find the advertisement was published on 2/11/2018.
2018.
Yes, my lord. The Mahila Sabha was conducted on 28/1/2019. And I secured 39 votes, whereas opposite party number 6 secured 38. Appointment order was issued in my favor on 8/2/2019. On 16/2/2019, the opposite party number 6 filed a writ application bearing WPC 4258/2019, my lord. That was disposed of on 25/2/2019, page 30. Now your lordship may turn to page 30 for a moment. Relevant person is page 32.
Yes.
Third paragraph. In course of hearing, Land Counsel for the petitioner states that highlighting the grievance, the petitioner has made representations to the authorities by Annex 3 series, but no decision has yet been taken. Opinion number to authority, but considering the limited grievance, the petitioner, without expressing any opinion on merits, this court disposed of the writ application directing the opposite party number 2 to take a decision. Well, opposite party number 2 was collector. Collector was taken, decision was taken. Then my lord, next page, your lordship may turn to page 33. On the basis of the direction issued by this honorable court, a miscase was initiated by the collector. 18/3/2019, order was passed by the collector. That case is posted to next page 1/6/2019. This is on 18/3/2019, my lord. The very next page 36, my lord. The petitioner, the opposite party number 6, again filed writ application 6/4/9/2019 on 19/3, the very next date, without suppressing the fact that the appeal is pending before the collector. Nor he has disclosed that before the collector that I have filed a writ application before the. Then my lord, collector my lord, page 38. So for this writ application is concerned 6/4/9, notice was issued on 3/4/2019. Thereafter, my lord, annexure 8, page 39, collector disposed of the case on 24/1/2020.
This is the earlier case. The earlier miscase.
Earlier miscase on the basis of 2495, 2458/2019, direction is given to the collector to dispose of the case. He has disposed of saying, upholding my appointment, my lord. Against that, he has filed another writ application, Annexure 9, page 42, 11886. On the ground
That collector is not the authority, appellate authority is sub-collector. Because earlier occasion, he has stated that I have filed a representation before the collector, that should be disposed of. And now, on the ground of jurisdiction, this unable to direct the sub-collector to again rehear the appeal. Now the sub-collector has passed the order by the annexure 10, my lord. On 7/12,
This order,
page 47.
no, Mr. Das,
Yes.
this order 13/7/2020 passed by a coordinate bench.
Yes.
Has it not been challenged?
Which one?
It was never challenged by you.
11886.
11886.
No, he has directed the sub-collector to rehear the appeal. Because
Does it not conflict the earlier order? Does it not contradict the earlier order? Because this court directed the collector to dispose of the matter. Now again, this court is again saying that the court cannot create a jurisdiction.
Because of the
Guidelines.
guideline.
I do, but anyway.
Court said that because collector should have transferred the matter to the sub-collector, that's why again the sub-collector has passed the order, my lord. That was under the subject matter of challenge. That 6447 is still pending.
So if we forget about everything,
Yes.
we only have the sub-collector's order.
And he has filed 6447, that is also pending during the subsistence of this writ application, my lord. He has withdrawn that case, my lord, on 3/7/2022, my lord.
No, anyway, the sub-collector's order is to be tested now.
Yes, that is to be tested now. Now, sub-collector order, I have challenged on two grounds, my lord, because the order of the sub-collector is contrary to the evidence on record, my lord. Your lordship may turn to page 51, annexure 11. And page 53, annexure 12. These are the
survey list.
Two candidates, my lord, opposite party petitioner and opposite party. No. The fact-finding authority, they were directed to calculate the votes secured by them. And they have fixed a modalities. On that basis, they have stated, my lord, page 52. My vote was 39. They have deducted 2 votes. Total vote is 37.
Where is that?
Page 52.
Page 52, serial number?
No, so मोट vote पाइଥିବା संख्या.
अच्छा, मोट vote पाइଥିବା
39 minus 2, they deducted 2 votes.
-2 काई करले?
तीटा कहि देते अलगा केंद्रर
लोकर देई दिछन. अच्छा, 37. तांकर
54. 39 minus 4, 35.
So yours is 37, he is 35. She is 35.
He is 35.
All right.
But sub-collector said the candidate which has been rejected by the authority, the fact-finding authority, that is subsequent to the Mahila Sabha conducted on 28th. So far as my case is concerned, nowhere it has been discussed why my votes were deducted, on what ground. Because I have filed document in my rejoinder indicating that the votes which have been deducted, my lord, I'll also turn to the rejoinder. On RTA Act, let's have got that. Yes. 8 of my rejoinder.
Yes.
एतो द्वारा आपन को जणाई दिया होछि कि आपन को द्वारा मगा जायथिबा सूचना हला जंबीराई, इट्स ए सेंटर, सुमति दास बेतगड़ियार तारामणि पाड़ी बड़कौदार सरस्वती राउत एवं अमिता राउत कर सर्वे होता लिस्ट अभिकरण एथिरे संलग्न करागला. नेक्स्ट पेज माय लॉर्ड, दिस इज विथ रिगार्ड टू बड़कौदार द अंगनवाड़ी सेंटर माय लॉर्ड. अमिता राउत एंड सरस्वती राउत, serial number 2 and 4. These two have been rejected, deducted from my vote, total 39 votes. But the sub-collector is silent about these two, why they were rejected. But so far as opposite part number 6 is concerned, you will also turn to page, next page, my lord, page 11. This is Betagadia, Anganwadi.
Yes.
Betagadia, next page 12, Taramani Pari, serial number 2. And next page 13, Jambirai 10. These are another center. And next page, page 14, serial number 2, Sumati Das. They belong to others. Now you will also turn to impugned order of the sub-collector, page 49.
Yes.
Last paragraph. It is ascertained after verification of the survey list and records of different Anganwadi center that Amita Raut, Pramila Raut and Saraswati Raut who have made their support in favor of opposite do not belong to Bodakota Anganwadi center. It's wrong because I have shown your lordship that two of them belong to this center. As they belong to Ratai Anganwadi center, their support to opposite part number 6, there I was opposite part number 6, is rejected on the ground of outsider. So the actual valid votes of Mahila Sabha by the opposite party is reduced to 36. He has reduced 3 votes. Number instead of 39. Similarly, Srimati Namita Das and Dipanjali Raut, who have made their support in favor of petitioner, do not belong to Bodakota. That is an admitted fact. The names of Srimati Sumati Das and Taramani Padi, who have made their support in favor of petitioner, have been deleted from the survey list, house number on 16-3 and 23 respectively, after the Mahila Sabha held on 21. Now your lordship has seen the report of the received on RTI, both of them belong to outsiders. They do not belong to. Now the sub-collector have included these two in the vote of opposite order 6, whereas they deducted 3 votes from me, causing 36 and 35. And held that opposite order 6 secured 1 vote more than the petitioner. He should have relied upon the fact-finding authority's report, my lord.
You have to give
fix the modalities.
Yes, Mr. Das.
Yes.
You have to give a specific reply to this. He has enclosed these documents obtained through the RTI Act. So these are not his documents. These are your documents. So you have to give a specific reply. This is purely on a simple examination of the survey list. Mathematical calculation.
Yes.
All right. Heard in part. Let this matter. No, heard in part. Sri R. Das, learned AGA, shall apprise the court with regard to the factual aspects referred to by learned counsel for the petitioner with regard to the deduction of votes in favor of the petitioner as well as the private opposite party. List this matter on 9th August. On 9th August.
Answer 15 series. Yes.
9th August.
Interim order to court.
Interim order to court.
May I mention that particular item number 17, it can be finished because pursuant to your lordship's direction, I sent a letter through registered post. She received that letter, but she has not sent any instruction. In that light, your lordship may dispose of.
Item kete?
Item 17.
Item 17.
Yes, that Anganwadi matter.
No instruction.
Yes. Nice.
Item 19.
May I please, your lordship?
Yes.
This was heard by your lordship on the in the last week.
In the last occasion,
this,
you wanted to clarity given that whether
appeal
there is
lies
any
against
provision
this
of
order
appeal.
or not.
In order dated 11/7/2024, the words alternate D, alternate, tapare gap D occurring in paragraph 3 shall be substituted by the word alternative. Hello. Yes, Mr. Mishra.
But your lordship wanted to know whether appeal lies or not.
What is this impugned order?
Impugned order is, my lord, removal of
Jogan Sahib.
Yes.
GRS
Oh, Gram Rozigar Sevak Rochi, yakar nahi.
Action under OPDR 2016 there is a provision for appeal, but with respect to the disengagement, I didn't find that.
Against an language.
All right, we'll then take it up.
So, my lord, this is a case your lordship has heard it, my lord. Your lordship will find this petitioner was appointed as a Jogan Sahib right in the year 2013, my lord. For the last 10 years, there was, my lord, for 10 years, my lord, there was no problem, my lord. Everything was, he was distributing the PDS material, my lord, very smoothly. There was no allegation, my lord, whatsoever. Now, after this new panchayat body came, my lord, the sarpanch, he demanded money from the petitioner. I refused, my lord. So that is why he tried to
my lord, put me to trouble. And my lord, particularly in the year my lord, in the year 2022, my lord, he said some persons, my lord, who made an allegation that the petitioner is not properly distributing the materials, my lord. My lord, so I filed my show cause reply saying that the Sarpanch has instructed the PEO to put a lock in the godown, so that, my lord, for that reason, my lord, I am unable to get the material for the supply to the, my lord, consumers, my lord. My lord, now an inquiry was conducted. In the inquiry, the authority found the PEO to be the major, my lord, as the, my lord, culprit, and imposed fine of ₹5,000 on the PEO, my lord. Whereas, my lord, the petitioner was imposed with fine of ₹500 because of some, my lord, cleaning, yeah, so far as cleaning of the is concerned. My lord, now, my lord, after that, since my lord, 5,000 cost was imposed on the PEO, my lord, the Sarpanch, he set a lady to lodge an FIR against the present petitioner, and the present petition under section 3 SC/ST Act, my lord. And after registration of the FIR, the petitioner was immediately arrested, my lord. So for a period during which he remained in custody, my lord, he could not distribute the materials. Now, my lord, for that reason, without conducting any inquiry, my lord, straightway an order of termination has been, my lord, given. Your lordship will find it at page 17 of my writ application.
I shall find.
He himself conducted a meeting in the Panchayat, and
yes,
this reason has been assigned, my lord. Your lordship knows, my lord, once I am taken into custody by the police, my lord, in my absence, my lord, I cannot distribute it. For that reason, without conducting any inquiry, my lord, without giving any notice of show cause, my lord, straightway this termination order has been passed.
My lord, Sarpanch has been included as a party in this case.
You are applying for?
Yes, sir. For the Sarpanch, I have filed the counter also.
So,
How can you justify this order?
yes.
How do you justify?
On the direction of the OP number 4, that is BDO, my lord, the Sarpanch has initiated the process.
लिखा ही नहीं आपन को order है? हाँ.
I have filed the
मंडल उन्नयन अधिकारी चिलिकांको पत्र संख्या एते कौन मालिक पदमारे ମାନେ ମାଲି ମକଦ୍ଦମା ହେତୁ ମକଦ୍ଦମାରେ ଜଡିତ ରହି ଟାଙ୍ଗୀ ଥାନା କେସ୍ ନମ୍ବର ଠାରୁ ଜେଲ କଷ୍ଟଡିରେ ଥିବାରୁ ଖାଉଟି ମାନେ ସେମାନଙ୍କର ସାମଗ୍ରୀ this cannot be sustained.
My lord,
He can be removed from service if he is convicted in the case after following the due process.
my lord, so,
Even assuming for a moment that he is not holding a civil post, at least the principles of natural justice ought to have been followed.
yes,
Or will be followed if at all he is found guilty in the SC/ST case.
yes.
But only because he could not distribute the food grains during that period in which he was in custody, I don't think this order can be sustained. What do you say?
My lord, I have filed one counter, my lord, on behalf of the opposite party 1, 2, and 4, my lord. And
What do you
there,
think?
my lord, we have only reiterated the same thing, my lord, that he actually could not properly discharge his duties. And with respect to that particular period,
We
that
cannot
is in
go,
parent-
you cannot go beyond the impugned order. In the impugned order, you have referred to a particular period. Where is that impugned order?
Yes.
Impugned order is at
both the parts.
page 17 of the writ application.
Impugned order consists of both the parts. My lord. That has been passed by the Sarpanch, my lord. He is to defend it, my lord. But when such a when such information actually came to the knowledge of the BDO with respect to his arrest and detention in judicial custody, then a letter was issued to the Sarpanch to take a
Take
decision to consider the same. But my lord, there was no direction from our side or the PDO side to disengage. So they took a decision in this regard, my lord, considering the past part, the failure on the part of the petitioner to discharge his duties properly and timely, and thereafter, my lord, taking into consideration additionally this particular aspect regarding detention in judicial custody and failure on his part to distribute during that particular period.
Let us read it in full.
Yes, Ambhe, it is next to Ambhe Hato Porodiho, Grama Panchayatra Sarpanch Vilas Behera, Sarpost Hato Porodiho, Tanatangi Sunsunso. ଆପଣଙ୍କ ଅବଗତି ନିମନ୍ତେ ଜଣାଇ ଦିଆଗଲା ଯେ ଆପଣ ଆମ ଗ୍ରାମ ପଞ୍ଚାୟତରେ ଯୋଗାଣ ସହାୟକ ଭାବେ କାର୍ଯ୍ୟ କରି ସରକାରଙ୍କ ଖାଦ୍ୟ ସୁରକ୍ଷା ଆଇନ ବଳରେ ଆସୁଥିବା ସାମଗ୍ରୀକୁ ସରକାରଙ୍କ ଧାର୍ଯ୍ୟ ସମୟ ଭିତରେ ବଣ୍ଟନ ନ କରି ଖାଉଟିଙ୍କୁ ତାଙ୍କୁ ସାମଗ୍ରୀ ପାଇବାରୁ ବଞ୍ଚିତ କରାଇବା ଓ ନିଜ ଯୋଗାଣ ସହାୟକ କାର୍ଯ୍ୟକୁ ଠିକ ଭାବରେ ବିନିଯୋଗ ନ କରି ଖାଉଟିଙ୍କୁ ହଇରାଣ ହରକତ କରୁଥିବା ସହିତ ସରପଞ୍ଚଙ୍କୁ ସମ୍ପୂର୍ଣ୍ଣ ଅଗୋଚରରେ ରଖି ନିଜ ଇଚ୍ଛା ମୁତାବକ ବେନିୟମ ଭାବେ ମନମୁଖୀ କାର୍ଯ୍ୟ କରୁଛନ୍ତି.
This is the first part.
This is the first part.
Where is the finding? This is just an allegation. Has any notice been issued?
There was an inquiry in respect of this matter, and I was found
The specific କିଛି ନାହିଁ କୋଉ ଡେଟ୍ ରେ ଆପଣ କଲେନି କଣ କଲେନି କିଛି ତ ନାହିଁ ନା ଗୋଟେ ଜେନେରାଲ ଟର୍ମସ୍ ରେ କୁହାଗଲା ଯେ ଆପଣ ଠିକ ଭାବରେ କାମ କରୁନାହାନ୍ତି.
Allegations receive କରିଛୁ ଯେ ତମେ
ଆଲିଗେସନ ଟା କଣ ସେଟା ତ କହିବାକୁ ପଡିବ
ନା written complaint ଆସିଛି ତାପରେ ଗୋଟେ inquiry ହେଇଛି and as it has been pointed out the same has been concluded with a imposition of fine.
fine on PEO as well as
if once a fine is imposed,
yes,
that recedes to the background. Now you cannot rake up that issue again. It will amount to double jeopardy.
Yes.
Isn't it? It will amount to double jeopardy.
Yes, ma'am.
ତାପରେ ମଣ୍ଡଳ ଉନ୍ନୟନ ଏଇଟା ସେକେଣ୍ଡ ଟାଇମ୍
So G/4 ରେ ଆମେ enclose କରିଛୁ document ଟା ଆମ କାଉଣ୍ଟର ଯୋଉଟା କି 500 rupees deposit କରିବା ପାଇଁ ଯୋଉ ଆମେ ତାଙ୍କୁ କହିଛୁ.
That part is over. That part is over.
That has been inquired by the and decided by the sub collector, licensing issuing authority. And he reached to a conclusion with
Anything you would like to add?
Only lordship, as per the direction of the video only, the Sarpanch has done.
And he says that the video never directed the Sarpanch to
take immediate.
No, this will not stand.
As
This
a
will not
lordship
stand.
adjustment.
Yes. Heard arguments. In the hearing concluded, judgment reserved.
Item 20.
Lordship, may be permitted to
Note.
small.
Please, please. Yes, yes.
So minor, but it's a case selection of a Shiksha Sahayaka. Well, for the recruitment year 14 and 15, my lord, I applied for the Balangiri district against my lord, the +2 teachers arts category 143. So my lord,
Annexer?
Annexer 2, page 15.
Balangir.
Balangir pay.
+2.
+2. 143.
Arts 143 vacancy.
+2 teachers, arts category.
143.
143.
Yes, then?
My lord, it's a problem. Letter part by the interference of the director OPEBA, it has list reshuffled ହେଇଛି ଯୋଉଟା କି goes in my favor. ମାନେ ସେଥିରେ ଯୋଉ ଆମର ରାଇଟ୍ ଅଫ୍ ପର୍ସନ୍ସ ଡିଜାବିଲିଟି ଆକ୍ଟ ଅନୁସାରେ ସେକ୍ସନ 34 4% shall be reserved for the physical hand category. ସେଟାକୁ ସେ କ୍ୟାଟେଗୋରାଇଜେସନ ହେଇଛି ସେ 4% ଟା ବି ଅର୍ଥୋପେଡିକାଲ ହ୍ୟାଣ୍ଡିକ୍ୟାପ୍ଟ ଗୋଟେ ନେବେ, ହିୟରିଂ ଇମ୍ପେୟାର୍ଡ, ଭିଜନ ଇମ୍ପେୟାର୍ଡ ଏଇଥିରେ ସେଟା କରିନଥିଲେ. ସୋ ବାଇ ଦି ଆଇ ଆପ୍ଲାଏ ଟୁ ଦି ଡାଇରେକ୍ଟର ଓପେପା, ମାନେ ଓପେପା Annexure 8, page 34. Page 34. ମୁଁ ଆସିଲି serial number ଚୈତନ୍ୟ petitioner ଚୈତନ୍ୟ ଚରଣ ପର୍ମା. My lord, ତାପରେ ସେ ଦେଲେନି. Again, by the interference of the Hon'Ble Court, counter re a fact is my lord disclosed and it is clarified. ସେ ତାଙ୍କ ଏଇ ଯୋଉ annexure my lord ଆମ ପାଇଁ ଦେଲେ orthopedical handicapped 1. তারপরে হিয়ারিং ইম্পেয়ার্ড 1
You are hearing impaired.
ନାଇଁ ମୁଁ ହଉଛି ଭିଜନ ଇମ୍ପେୟାର୍ଡ ଆମ ପାଇଁ ଦେଲେ ଦିଟା
ହଁ।
ହଁ ଦିଟାରୁ ବର୍ତ୍ତମାନ ସେ ଅନରେବୁଲ କୋର୍ଟଙ୍କ ଅର୍ଡରରେ ଇଏ ହିୟରିଂ ଇମ୍ପେୟାର୍ଡ ଆପଏଣ୍ଟେଡ ଏ ସେକେଣ୍ଡ ବେଣ୍ଡ ଆଉ ଅର୍ଥୋପେଡିକାଲ ହ୍ୟାଣ୍ଡିକ୍ୟାପ୍ଡ ଆଇ କ୍ୟାନଟ୍ ସେ ମାନେ ଆଇ ବିଲଙ୍ଗ ଟୁ ଦ ଥାର୍ଡ କ୍ୟାଟେଗୋରୀ ଫିଜିକାଲ ଭିଆଇ ଭିଜନ ଇମ୍ପେୟାର୍ଡ 2 ତେଣୁ ମୁଁ ସେଥିରୁ ସେଇଟା କି ଯୋଉଟା ଇଣ୍ଟରଫିୟର କଲା ପରେ ଡାଇରେକ୍ଟର କହିଲେ ହି ୱିଲ୍ ଗେଟ୍ 1 ପୋଷ୍ଟ ଏଇଟା ହେଇନି ଦେଇନା ଏତିକି ମାଇ ଗ୍ରିଭାନ୍ସ ଏଇଟା ହେଲ୍ପଫୁଲ ଟୁ ମି ଏଇ ଯୋଉ ଡିସକ୍ଲୋଜରଟା annexure A/4 ଟା
What is their stand?
We have stated in paragraph 10 of the counter as to what has happened.
ହଁ ହଁ ଆମର 9 ରେ ବି ଲେଖିଛୁ हम ठीक କହିଛୁ ହଁ yes 10 ଟା ମଧ୍ୟ କାଉଣ୍ଟ ମୁଁ ପଢି ଦଉଛି କାଉଣ୍ଟର 10 ଟା it is humbly submitted that as per allocation of vacancies to Balangiri district by OPEPA there was one post meant for physical handicapped, one post hearing impaired under plus 2 city arts category. Accordingly, one PH hearing impaired candidate named Jitendranath Mishra applied Balangiri as his first preference district, was selected and posted while filling vacancies out of candidates preferred Balangiri district as his first preference district. As such, one vacancy of PH hearing impaired post under plus 2 city arts category has already been filled up during process of engagement of first preference candidate. In view of the facts, the order dated 4/1/2021 passed by the state budget at OSEPA rejecting the representation is unjust, is just and proper. अति खाली से hearing कथा कहा हला, but out of the category रही गला. So मतलब जितेंद्र got appointment ସେଇଟା मतलब hearing impaired.
You come to annexure 8, page 34.
Page 34.
You are Chaitanya Charan Pramanik.
Chaitanya Charan Pramanik.
Your category is hearing impaired.
ନା ଏଇଟା ଭୁଲ hearing ମୁଁ vision
ଲେଖା ଅଛି
ଭୁଲ କରିଛୁ ଏଟା ମୁଁ ଆମର ଆନେକ୍ସର ଦେଇଛି ଏଇ ଯୋଉ ଇଏ ସାର୍ଟିଫିକେଟ ଟା ଡିଜାବିଲିଟି ସାର୍ଟିଫିକେଟ ଟା ବାଇ ସିଭିଲ ମେଡିକାଲ ବୋର୍ଡ ଆମ ପାଇଁ ଦିଟା ଅଛି ଦିଟାରୁ ସୋ ଆଇ ୱିଲ୍ ଗେଟ୍ 1
find out in view of your
10 ଟା it is disclosed.
If this annexure 10 is still pending, this was since February.
Why should we again release him? If this is the position, then you can only take instruction, he can be engaged.
Yes. Because post is there.
If there is any vacancy.
It's already settled thila.
No, you take instruction.
36 ରେ ମାଇଲ ଅଛି section 36 ରେ they will carry forward the first
that I know. Yes.
Yes lots.
In course of hearing,
my lord,
Sri Mahathir and counsel for the petitioner draws attention of the court to the document enclosed as annexure A/4 to the counter filed by 4, wherein 4 posts have been kept reserved for physically handicapped candidates in the following manner: PH bracket OH1, PH bracket HI1, PH bracket VI2 under the this is in relation to the +2 teacher apps against 143 total vacancies. Stop. Srimati further refers to the averment in the counter affidavit under paragraph 10, wherein the candidature of the petitioner, wherein rejection of the candidature of the petitioner has been sought to be justified on the ground that one vacancy of PH bracket HI category has already been filled up. Stop. Srimati submits that the petitioner does not belong to PH bracket HI category, but PH bracket VI category, of which 2 vacancies are available. 2 vacancies have been shown in the document marked annexure A/4. Stop. State Council shall take instruction as to as regards the availability of vacancies in the PH bracket VI category, and if the petitioner could be appointed against the same. Stop. Please this matter
16th August.
on 16th August.
Item 21.
May I please, Your Lords? The petitioner is a selected Anganwadi worker.
Okay.
The opposite pattern of
OP number 4 has not yet appeared. Counter AD is not back. Let us see the postal tracking.
no notice was issued. Last occasion, Your Lordship had to take instruction regarding the caste of the father of the petitioner.
Yes, that.
Hey, notice be issued to OP number 4 bhi achi.
Open 4 is child development. Open 5. Open 5 की notice है. Child development officer open 4 is government CTPO.
और ओटा ही नीचे हो. But notice was, I think requisites were also filed accordingly. Yeah, notice was issued. Who's opposite party number 4?
Here is CDP.
CDP.
You got Sulochana Mamudi case 36829.
No, wrong ta de di chode.
36829.
21 में wrong ta khol deli. What is the noting here? No, it is ready. It is otherwise ready.
Yes. Yes, counter already filed, only take to instruction thereafter.
Instruction.
The only thing is that whether the father of the petitioner belongs to scheduled tribe or not.
Scheduled tribe or not.
What has happened? What is the matter?
No. Matter is the petitioner is selected as Anganwadi worker. The OP number 5 filed the appeal. Appeal was allowed on the 2 grounds. One is the petitioner does not belongs to scheduled tribe. Why? Though the petitioner father has no land and the father does not belongs to scheduled tribe. On that ground, the appeal was allowed.
What is your instruction?
No, the instruction is, as per the villager statement, Mukhi Khol, Srimati Sulochana Mamudi got married to an Adivasi person, scheduled tribe person, and living at Paji, such and such village. And her father, Mamudi Karalu, also married to a scheduled tribe woman, but they are not scheduled tribe. That was were not scheduled tribe, but they got married. Her father got married to a scheduled tribe woman and living as per scheduled tribe traditions and culture in Munikol. The villagers of Munikol state that Srimati Sulochana Mamudi and her father belong to scheduled tribe category. Again, that has been this statement from villagers. It
is true that her mother belongs to scheduled tribe.
As per the ROI, which comes on.
No, is clear?
As for the revenue records, they come under the general category, the father. But as per the villager statement,
the villager statement, RI has to submit a report. There has to be a caste certificate is to be issued by the sub collector.
yes,
Sub collector, I think.
on the miscellaneous certificate rules.
No. As ST, the inquiry is to be made by the RI and.
Annex 6, page 32, the caste certificate.
This is considered to be wrong, isn't it? But Kondho is, I think, scheduled tribe. It is there in the presidential order.
Scheduled tribe.
Yes. This certificate says Kondho, is it not accepted?
But the record of it is otherwise.
Appeal, the London ADM directed for an inquiry, and from the inquiry, he stated that the caste certificate of the father of the present petitioner belongs to NT Dora, which belongs to OBC category. so that he found that the certificate produced by the petitioner is not genuine. So she does not belongs to scheduled tribe matter. But however, the mother of the present petitioner is belongs to scheduled tribe. The ROR in the name of the father of the mother is scheduled tribe. I have the document. Secondly,
So what will happen in a case where the mother is a scheduled tribe, father is a non-scheduled tribe?
there is a
What
judgment
will be the caste of the child?
It will be scheduled tribe.
No. So there must be some notification or some clarification issued by the SC/ST department.
There is a judgment of the Honorable Appeals Court where it is clarified that if the mother of the child belongs to scheduled tribe, then he is born and brought up as a scheduled tribe, then it will treated as the scheduled tribe category. Even if his father belongs to general category. Well, what you can see the paragraph 55. The last portion. Also noting also.
You go through this judgment. Go through this judgment so that you can, in course of hearing, when counsel for the petitioner cites a judgment of the Supreme Court rendered in the case of Ramesh Bhai, Dabhai, Naika, versus State of Gujarat and others. Let a copy of such judgment be served upon Land State Council. Counsel for both parties are directed to address the court with regard to the ratio decided in the said judgment on the next date. Place this matter on
9th August.
9th August.
I humbly pray that notice may be issued to open our file. The interim order may be granted.
Notice जाइनी?
No. Instruction to decide whether father the petitioner is belong.
We'll take it up on that day. We'll consider it on that.
If they proceed already, they have removed the petitioner from the job.
अब कौन करा जीव होता?
Subject to final outcome.
Yes.
Subject to
Any action, any action taken pursuant to court order कहीं? Input order कहीं?
Annex 1.
Pursuant to order dated 27/7/2023 shall be subject to the result of this writ application.
Item 22.
Maybe, right. In this case, the sole grievance of the petitioner is that petitioner is claiming they are not allowed to perform our duties and the arrear salary.
We'll also find out service of notice on opposite party number 4, the Sarpancha. Notice was issued, but AD has not come back.
Submit my lord. See, that gave opportunity was given to the opposite party number 4, but the sole grievance of the opposite party number 4 is that annexure for page 10 kindly.
No, but he has not been served with notice.
That I am submitting. You give time, my lord. Annexure for page 10. Earlier, the petitioner approached that you release the arrear salary, they did not arrear salary. But in personal affairs, annexure for page 10, they stated that during course of hearing, Learned Counsel for the state submits that petitioner has already been paid with the entire arrear salary till date, that is 29/11/2023. On the basis of the instruction of the Sarpanch in personal affairs, the writ petition has been dropped. But when I take the information that they give the salary up to May 2023. I approached again, and due to I filed this case for a release of salary, they did not allow to perform my duties. So in that case, again, when this case notice the Sarpanch has been called for on dated my lord, and Sarpanch appear on 2/1/2024. On that date, he submit that Para 2, in response to the order passed by this court on 19 the Sarpanch Gangraj V appears through virtual mode and submits that petitioner has already been paid with her salary till the month of May 2000, and thereafter no salary has been paid to the petitioner because she remained absent for that period. In that, they stated that till date they have been paid the salary. On that basis, they dropped the writ petition. But when the again personal affairs, they did not give the salary from the June to November and did not allow, they said that they did not perform their duties. Every time going to they are not allowed to perform their duties. For that reason, this Honorable Court directed to file the reply to the writ petition. This is the my till they are not allowing me to perform my duties. Since after filing the first writ petition for release my earlier salary. And they stated that he is absent.
No, that's all right, but the problem is without sufficient notice, I cannot proceed. You can do one thing. The postal tracking report मिलियो 6 मास ହେଇଗଲା ନା ଆଉ that will not show anything. You take fresh notice by speed post. There at least on the basis of the postal tracking report, we can, if he doesn't appear, notice can be held sufficient.
May pay my lord. So the direction may be given to the State Council so that he will be appear, because on that date he appeared and that he appeared and said that you
do one thing. You can serve the notice through the video also.
That they are able to file counter.
No. He on the surplus. He can serve the notice. The video can serve.
That can
to the office of the video.
Yes.
Let an extra copy of the writ application be served upon the State Council, who shall cause the same to be served on opposite party number 4 through the video. Through video? Through the video,
Kuliana,
Kuliana, District Mayurbhanj. Indicating that the matter shall be taken up for hearing on, what a short date for
16th August.
16th August. You shall the
I may be allowed to perform because they are only sole grievance because
yes, the petitioner, in the meantime, the petitioner shall be permitted to perform his duties if there is no other legal impediment.
Obliged.
23. On to behalf of Budhiram Das next week, my lord.
Next week.
Item 24.
Yeah, please, my lord. Here in this case, my lord, the petitioner praying for regulation of service after completion of 6 years since the date of appointment, but they have regularized on 2023. So they to file a counter. Last time the state have taken time to file a counter, but they have not filed.
All right. 2 weeks time is allowed to the state to file counter. Let this matter
16th August.
on 16th August.
25 is same, my lord.
25 same.
My lord.
Item number 56.
My lord, transfer of matrimonial from Papadjapur to Patnagarh.
Yes, notice. State Council, notice.
The notice is this appearing.
Here appears.
Opposite party.
Can you appear?
In fact, the IIC has reported that on local inquiry, it is learned that Hemanta Behera and his family members are absent from his house since about 6-7 months. 7-8 months. On being asked, nobody of the locality as well as nearby villages could be able to say anything, say about their present location resident. In this respect, the local ward member furnished a written intimation having a signature of witnesses. That has been also given. So this being the position, notice could not be served on him.
All right, we'll do one thing. We'll ask the court below to inform whether he is appearing. If he is appearing, the notice be served.
Yes, that can be done.
And State Council informs that the local IIC has informed that the family of the opposite party husband, Hemanta Behera, and his family members are absent from their
7-8 months
from their house since 7-8 months.
7-8 months.
7-8 months. The local people are unable to say anything about their whereabouts. In such view of the matter, the court below is directed to inform whether the whether Hemanta Behera is appearing in mat suit number 9 of 2020 on the dates fixed. If so, let a copy of the transfer application. If so, if so, he shall be informed about the date fixed for hearing of this case. List this matter on 23rd August. This order will be communicated to the court below forthwith.
Interim order to continue.
Interim order to continue.
Item 27. My lord, on behalf of the district, I'm the opposite party.
Yes. What do you want?
On behalf of Udhiram Das.
Yes, what do you want?
Time next Monday.
For the petitioner, my lord. Petitioner has prayed for transfer of civil proceeding from Leonard Judge.
Anyway, he's asking for time.
Bolangir, my lord.
2023. Next week. Next Friday. Let's just matter next week as per.
Interim order to continue.
Interim order to continue.
Item 28.
28 my lord, on behalf of Mr. Abhinarayan Mahat, my lord, during pendency of the TRPC, my lord, the lower court passed expiry order, my lord. The petitioner filed is CMP. The case is posted to 7th August, my lord. Kindly taken up.
CP already been disposed of expertise.
He has filed a petition for recall.
Last occasion, same submission was made. No notice has been issued till yet. The lordship may see the last order. Prior to this, my lord, section 9 application was also filed. He did not appear. That was also expiry order was passed.
I'll grant him one more opportunity. If he doesn't appear, Sri Mahathir and counsel for the petitioner submits that that CMA number 2054 of 2024 is posted to 7th of August for hearing. List this matter on 16th August.
17 August ko achi.
17th. 17th August. So list this matter on 30th August.
Item 29. Not in this case, my lord. In the last occasion, your lordship directed to take the instruction whether there is a mutual or not, the agree, there is a discussion. So, 5 lakhs that is agree to pay, and jo gharota achi, 50-50. And permanent alimony discussion 10 lakhs. That is the.
So file a joint petition. Well, file a joint petition. If otherwise, you can file a joint petition before the court below.
In this direction will get.
And this case, so the case will not be transferred anymore.
Yes.
All right.
Next week was my lord more instruction.
What instruction?
Observe कौन ताने कुछ कोई ना दे
Dates in Netherlands. Sir, discussion ହେଇଛି out of.
Leonard Senior Council appear होते.
Tinta date ନେଲେ କେତେ ନେଲେ?
ଆଗରୁ ଦିଟା date ହେଇଛି.
ଏଇଟା କହିଲା ପରେ ଏଇଟା ତ last time ଆପଣ କହିଲେ ଆଉ
last date ରେ 31/1 ରେ 2024 ରେ Hon'Ble court directed ଯେ
all right.
Thereafter 2 days.
Sri S.K. Das, Leonard Counsel for the petitioner submits that the dispute between the parties has been amicably resolved. Sri Sahul, Leonard Counsel for the opposite party, wants to take instructions in this regard. List this matter next week.
Gratefully.
And it put that to.
Yes.
In the meantime, interim order continue करना से टीम राउरकेला जोड़े चालीस सीट
Interim order कौन थिला? Adjournment.
पहले से adjournment till dispose of this. Item 30.
Mediation Center.
My lord, mediation is failed. Report is at flag X.
Report of the mediator indicates that the mediation between the parties has become unsuccessful. So,
May I pray one thing, my lord? Kindly permit for video conference.
yes.
Kindly permit for video conference hearing through.
Yes, what do you say? ताकर कौन को यार? You are for the wife.
I'm for the wife.
Yes. Therefore, transfer has been made on behalf of the husband of the opposite party of CR criminal miscase number 1 of 2024 pending before the learned Nyadhikari Gramanayala come JMFC Korukunda in the district of Malkangiri to the court of learned SDJ Mathawad. Transfer is sought on the ground that the petitioner is a resident of Koti, Cuttack.
Yes, ma'am.
He is a resident of Cuttack.
Nagar, Abhinapur, Badamba, Cuttack.
He is a resident of village Muktanagar in the district of Cuttack. As such, it will be difficult. Now, further, his parents are old and ailing. Further, Malkangiri is at a distance of more than 500, actually 600 kilometers.
600.
More than 600 kilometers.
Almost about 700 kilometers.
Yes.
Almost about 700 kilometers.
Yes. Malkangiri is at a distance of 500 kilometers from Cuttack. As such, it would be difficult on the part of the petitioner to attend the court on the date fixed for hearing of the case. Therefore, transfer has been opposed by the opposite party wife on the ground that she is a resident of Malkangiri. And therefore, it would be more inconvenient to her to travel to Cuttack if the case is transferred.
Travel to Athawad, Your Lordship.
Travel to Athawad. Considering the submissions and the relative inconvenience that may be caused to the parties if the case continues at inconveniences of the parties, this court is of the view that it would be more inconvenient to the wife if the case is transferred from Malkangiri to Athawad. In such view of the matter, I am inclined to allow the prayer for transfer.
Dismiss. The transfer is.
I'm sorry. In such view of the matter, I am not inclined to allow the prayer for transfer, which is therefore dismissed. It shall, however, be open to the petitioner to seek permission of the court below to appear through virtual mode. Moreover, yes.
If necessary, he'll appear physically. If necessary. I have no objection.
You have filed a case at Malkangiri only to drag him to 700
No, Your
kilometers.
Lordship. My father is serving at Malkangiri.
So you have gone away to reside there and to give your husband to Malkangiri.
I have any other option other than residing with my father, Your Lordship.
Asu. 700 kilometers. Anyway, that order will be passed that physical attendance will not be necessary unless it is absolutely necessary. It will not be necessary.
That's what I meant.
Item 31.
31 mediation report.
31, I am for the opposite party husband, Your Lordship.
The mediation report indicates that the report of the mediator indicates that the mediation between the parties was unsuccessful. Why are you wearing a mask?
I have that jaro hegla se bahar jaisa ore.
The President of America has got again COVID. You guys read in the newspaper.
Era su jaro re bahar gela to te. I am for the opposite party. My friend is for the petition.
Yes, Mr. Mulya.
The husband filed a divorce petition.
You are the wife?
I'm for the wife, madam.
Yes.
Husband filed divorce petition at Jagasingh, madam. His present petition wife is residing at Pulnakla. The district lady is having a breastfeeding child.
You will allow it?
Lordship, only
she herself stated that in Cuttack or Bhubaneswar.
Bhubaneswar.
May I pray it let it be in Cuttack, your lordship?
There is two proceedings pending before the Bhubaneswar.
You yourself asked for Cuttack or Bhubaneswar?
Yes.
Bhubaneswar.
That proceeding কথা হচ্ছে petition
ଆପଣ ନିଜେ କରିକି ତାପରେ ପୁଣି ଆପଣ କେମିତି ମନା କରିବେ?
Oblique ଅଛି.
Oblique ଆସିବନି. What is the meaning of oblique?
that the two proceeding which my learned senior friend referring, she has not whisper anything in her petition, your lordship.
No. The petitioner wife seeks transfer of CP number 294 of 2023 from the Court of Learned Judge, Family Court, Reservation to the family courts at Bhubaneswar, family court at Bhubaneswar or Cuttack. Therefore, transfer has been made on the ground that the petitioner is residing at Fulnokara and has a small breastfeeding child. As such, it would be difficult on her part to travel to Jagatsinghpur to attend to the case. Learned counsel for the opposite party opposes the prayer for transfer on the ground that he is a resident of Jagatsinghpur. Yes. Considering the submissions and the relative inconvenience of the parties, this court feels that this court is of the view that it would be more inconvenient to the wife rather than it would be more inconvenient to the wife if the case is allowed to continue at Jagatsinghpur. As such, I am inclined to allow the prayer for transfer. Hello. कोई करते हो virtual mode भी देगा.
Item 32.
देख रहे हो 32 गोटे पास ओवर कर दो.
Item 33.
अर्जुन कर दो. अच्छा हो पास ओवर.
Miller, I am not feeling well. Next week, Miller.
Next week as paid for. Yes, Mr. Proceed.
Next week.
All right.
Item 34.
34.
May I please?
Item 35, seeking for time to filing the counter mail.
Counter कौन?
Mail, why I am submitting mail in the family court Raigada in conciliation is going on in a execution case. So counter टा बतन फाइल करे तो conciliation को हम पर हो. ये section 9 ने move फाइल करते लिए Jasper family court. There is a stay order.
Please this matter on
9th August.
On 9th August, as paid for by learned counsel for the opposite party. Yes. Intermodal to continue.
Item 35.
I am for the opposite party, my lord. Who is for the petitioner? All right, pass over.
Allow the last.
Petitioner जो उतरे ना थे तो गोटे पास ओवर तो दवा. फिर पछाड़े पुणे आसिए.
Sir, intermodal tank के बराबर.
Item 36.
36.
For the petitioner,
I have appeared, I have entered appearance on behalf of the husband. In this case, Asu would have appear court.
Is there any chance of settlement?
ଆଜ୍ଞା ମୁଁ ସେଇଥିପାଇଁ କହୁଛି ଗୋଟେ ସେଟଲ କରି ସେ 6 ବର୍ଷ ହେଲା ପଳେଇ ଆସିଲାଣି ମୋ ପାଖରେ. ମୁଁ ରହୁଥିଲି ସେ ରହୁଥିଲେ ସୁନାବେଡାରେ. ସେ ତାର ସେଠି ଗୋଟେ କଣ ଗୋଟେ ସମ୍ପର୍କ ଘଟିଲା ଆଉ ଗୋଟେ ଲୋକ ସାଙ୍ଗରେ ତାକୁ ନେଇକି ସେଠି ପଳେଇ ଆସିଲା. ତା ବାପ ଘର ହଉଛି ଆମର ସୋରରେ. ବାପ ଘରେ ସେ ରହୁନି. ସେ ଟୋକାଟା ପାଖରେ ରହୁଛି ବାଲେଶ୍ୱର. ସେଇଠି ସେ ଫାଇଲ କରିଛି କେସ୍ ମୋ ଏଗେନ୍ଷ୍ଟ. ମୁଁ ରହୁଛି ସୁନାବେଡାରେ.
କଣ ଆଉ କରିବା?
ନାଇଁ ସେ ହୁଏ କାରଣ ଗୋଟେ ଝିଅଟେ ଅଛି. ଝିଅ ମତେ ମେସେଜ ଦଉଛି ବାପା ମୁଁ କଣ ଭୁଲ କଲି. କାନ୍ଦ ମାରୁଛି ସେ କଥାଟା ସେ ପେସେଣ୍ଟ ଯୋଉ କାଟୁଥିଲା. ସେ କହୁଛି ବାପା ମୁଁ ଭଲ କଣ କଲି କିନ୍ତୁ କରିଛି ତ ଯିଏ ତ କରିଛି ସେ ତ ବାଲେଶ୍ୱରରେ ଅନ୍ୟ ଜଣ ପାଖରେ ଅଛି. ମୁଁ କଣ କରିବି? ମୁଁ ତଥାପି ଇଣ୍ଟରେଷ୍ଟେଡ ଟୁ ଟେକ୍ ବ୍ୟାକ୍.
Leave this matter
9th August.
on 9th August.
intermodal to
करते.
ଆରେ ତାକୁ ସେଟଲମେଣ୍ଟ ଗୋଟେ କନସିଲେସନ
नहीं जी ଆପଣ କହିବେ ଏବେ ତ ମିଡିଏସନ କୁ ପଠେଇ ଦେବି.
ହଁ ମିଡିଏସନ ପଠେଇ ଦେବି.
Yes, what is it, Mr. Pradhan?
but cost may be paid in a distress condition, but payment may be made so that she can come.
ସାଙ୍ଗରେ ଆସିଲେ ମୁଁ କଷ୍ଟ କରିବି କିନ୍ତୁ ସେ ଅରୁଣ ମିଶ୍ର ଯିଏ ଆଉଛି ତାକୁ ଧରିକି ଆସିଲା ମୁଁ କେମିତି ପଇସା ଦେବି? ସମ୍ଭବ ନୁହେଁ.
ନାଇଁ କାଇଁ
ମୁଁ ନେଇଯିବି
false allegation.
ଠିକ ଅଛି ମୁଁ ନେଇଯିବି ତାକୁ କିନ୍ତୁ ସେ
ଆଚ୍ଛା ସିଏ କାହା ସାଙ୍ଗରେ ଆସିବେ ଆପଣ କେମିତି ଜାଣିଲେ?
ଆଜ୍ଞା ସେ କେୟାର ଲେଖିଛନ୍ତି କେୟାର ଅଫ ଅରୁଣ ମିଶ୍ର ସେ ଭଟ୍ଟରେ କିନ୍ତୁ କେୟାର ଅଫ
ଅସୁବିଧା କଣ ହେଲା ସେଠୁ ତାଙ୍କ
ସେ ଅରୁଣ ମିଶ୍ର ଯିବ
ଆପଣ ସେମିତି କହିପାରିବେ ଯେ ଅରୁଣ ମିଶ୍ର ଆସିଲେ ପଇସା ଦେବେନି?
ନା ନା ସରି ଆଇ ଏମ୍ ନଟ୍ ଟେଲିଂ ଦ୍ୟାଟ୍ ଆସ୍ପେକ୍ଟ ମୁଁ କହୁଛି ଜଣେ ଯଦି ଚଳୁଛି ଭଲରେ ତା ଘର ବୁଝୁଛି ତା ପାଖରେ ରହୁଛି ତା ପିଲା ସେଣ୍ଟ୍ରାଲ ସ୍କୁଲରେ ପଢୁଛି ତେଣୁ ସବୁ ସେ ବୁଝୁଛି ଆଉ ମୁଁ ଏଠି ଗାଡି ଭଡା ଦେବି କାହିଁକି ଏଠିକି ଆସିକି ସେ ଗୋଟେ ଥର
ହେଲା ଠିକ ଅଛି। In course of hearing, both learned counsel for the parties submit that it is stated at the bar that the nature of the dispute between the parties is such as can be settled through the process of mediation. In such view of the matter, let the records be placed before the coordinator Odisha High Court Mediation Center, who shall do the needful. Parties are directed to appear pursuant to receipt of notice from the mediator and to render full cooperation in the mediation proceeding. List this matter on 20th September interim order to continue.
अच्छा कॉस्ट में
नाम में cost नहीं.
आसुओ केम जाए डिस्ट्रेस
Pardon me, Lord. Item 33, interim order.
33 interim order to continue.
Item 37. नहीं 37 ना से लास्ट टाइम पोस्टल अथॉरिटी की मैनेज करके फेरे देथिला subsequently your lordship has directed to serve extra copies on the state council so that the notices can be served.
What happened?
No, there has been some mistake in the address of the IIC that has been given by the petitioner. No, Moidaspur in the district of Moidharpur.
Hindol space.
Moidarpur is just near to Hindol.
Moidharpur.
Lagichi. But there will be two different police stations. What is the
Hindol?
No information.
She has filed an FIR.
No.
She has lodged an
No, Mr. Satpathy, he does not have that information.
Yes.
Learned State Council requests for some time to obtain instruction regarding service of notice on the opposite parties. Let this matter on 2nd August. The previous order be complied with positively. Yes.
Second August. That पर सकता हूँ.
9th August.
Interim order to continue.
What was the interim order?
Stay of the proceeding of the case.
All right. Interim order to continue.
Item
So
38.
this I am sorry. This address is correct. Moidharpur, ढेंकानाल.
Moidarpur ढेंकानाल, but the PS is Hindol.
କାହିଁକି ମଇଦରପୁର ତ ନିଜର ପିଏସ୍ ଅଛି ବୋଧେ?
ଯେ ହିନ୍ଦୋଳ ଥାନାରେ ସେ ଗୋଟେ ଏଫଆଇଆର ଦେଇଥିଲା.
ନାଇଁ ଦେଇଥାଇପାରେ. ଆପଣ ଆଡ୍ରେସ କଣ ଦେଇଛନ୍ତି?
ଆଡ୍ରେସ ସେୟା ଦେଇଛି.
Now which PS then?
Which PS? I have said jurisdictional police station. So you will have to pinpoint.
ଏ ଗୋଟେ ଦେଇଥିଲେ ସେଟା
Moidharpur.
Already find out and give the yes item 38.
Item 38, if I have please, Your Lordship, I am appearing on behalf of my learned senior, Mr. Bhunya. As per the noting, due to clerical error, the requisite
filed be accepted and notice be issued, fixing a short returnable date. List this matter
16th August.
on 16th August.
Much obliged.
South of Chitra.
Passover item.
Number 39, the next item.
If my name reflects my lot, I think.
as per statement of one Ananta Behera, who is an accused.
Kindly settle down, Mr. Boss. No, please settle down. Yes. What has happened?
Statement, my lord, of the co-accused, one Ananta Behera, who was taken into custody. On his statement, my lord, the petitioner implicated in this case, my lord.
Where is that implication? How do you say that?
I am read out the statement of Vikas Sahu.
Yes.
ଏଇକି ଯେ ମୁଁ ମୋର ସାଙ୍ଗ ଆମ ଗ୍ରାମର ପ୍ରଶାନ୍ତ ସାହୁ ଆଜି ସକାଳେ 6:45 ହେବ ଆମ ଗ୍ରାମର କାମ ପାଇଁ ଥାନାକୁ ଆସିଥିଲୁ। ଏହି ସମୟରେ ଏସଡିପିଓ ସଦର ଥାନା ଷ୍ଟାଫ ଜଣେ ଯୁବକକୁ ଧରି ଥାନାକୁ ଆସିଲେ। ସେଇ ଯୁବକ ଆମ ସାମ୍ନାରେ ପଚରି କରିବାରେ ସେ ରେଗେଡି ପାଖରେ ଗତ 13/9/2022 ହୋଇଥିବା ପୂର୍ଣ୍ଣ ନାୟକ ମର୍ଡରରେ ସମ୍ପୃକ୍ତ ଅଛି ଏବଂ ତାର ଦୋଷ ସ୍ୱୀକାର କରି କହିଲା ଯେ ତାର ନାମ ଅନନ୍ତ ବେହେରା, ପିତା କୃଷ୍ଣ ବେହେରା, ଗ୍ରାମ ସୁଆଣ୍ଡସୋ, ତାଙ୍କ ପଞ୍ଚାୟତର ରାମସା ନାରାୟଣ ଗ୍ରାମର ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ନାୟକ ତାକୁ ଗତ ଜୁନ ମାସରେ ରାଜନୈତିକ ଆକ୍ରୋଶ ରଖି ଆକ୍ରମଣ କରିଥିଲେ। ଏହା ପୂର୍ବରୁ ବଡମହୁରୀ ଗ୍ରାମରେ ଭୂତ ରାଉଳ ଓ ଅନ୍ୟମାନଙ୍କୁ ହାଣିଥିଲା। ଉକ୍ତ ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ନାହାଙ୍କ ନାମରେ ଏମାନେ ପୁରୁଷୋତ୍ତମ ଥାନାରେ କେସ୍ କରିଥିଲେ। ଏହାପରେ ମଧ୍ୟ ସେ ଏମାନଙ୍କୁ ଆକ୍ରମଣ କରିବା ପାଇଁ ଯୋଜନା କରିଥିଲା। ତେଣୁ ଉକ୍ତ ଅନନ୍ତ ବେହେରା ବଡମହୁରୀର ଭୂତ, ଚିଙ୍ଗୁଡି ଘାଇର ବାବୁ ଓ ଭୂତର ସାଙ୍ଗ ଶୁଭମ ସେଠୀ ଓ ଶମ୍ଭୁ ସେଠୀ ଦ ପିଟିସନର ମାନେ ବିଷ୍ମଗିରି ଥାନା ମିଶି ଯୋଜନା କଲେ ଯେ ସୁବିଧା ଦେଖି ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ନାହାକୁ ଜୀବନରେ ମାରିଦେବେ।
Well, then they say 3 SC/ST 302, so
No, SC/ST not against the petitioner since he belongs to SC/ST.
how can we say that?
No, that charge sheet your lordship kindly peruse. Charge sheet SC/ST is not there.
Have you filed the charge sheet?
No, I have with the certified copy, my lord. Your lordship peruse. I have underlined.
All right, first or second.
ନାଇଁ ଆନାର କିଛି ନାହିଁ co-accused statement ରେ ମତେ କରିଛନ୍ତି।
See, co-accused statement, I will make that observation. The petitioner is appearing.
Direct, I will surrender, my lord. I will cooperate with the investigation, my lord.
No. The petitioner is
I am not named in the affair.
All right, petitioner is apprehending arrest in connection with such and such case. It is submitted that the allegation is that some persons killed. Ki se logda na, je deceased?
This is Purna Chandra Nahako.
One Purna Chandra Nahako. Out of previous grudge.
FIR named accused is 25 in number, man.
The petitioner is not named in the affair. So 25 persons have been named. He was implicated on the basis of the statement of the co-accused. Further, charge sheet has been submitted against him,
Ananta Behera, my lord,
deleting the offence under section 3 of SC/ST Act, as he himself belongs to the SC community. Having regard to the nature of accusations and the materials on record, first hour, second hour, in considering the bail application, the courts below shall take note of the fact that there is no independent evidence against the petitioner, save and except the statement of there is no independent.
One another accused also said, my lord. One
co-accused statement तो हबो सेटा कोन
he was present at the spot. से भी थिला
थिला ठीक है।
Yes, my lord.
Except the confessional statement of the co-accused. Yes.
all have been granted bail by this honorable court.
All right. Further, the court below shall also maintain the principle of parity.
Yes. Same day
disposal, definitely.
Item 41.
The petition is in custody since 8/2/2021.
Yes.
Petition in custody since 8/2/21. 20B 2C of NDPS Act. The quantity of ganja involved 128 kg. And the petitioner is the driver of the entry car.
Driver of the entry car apprehended at the spot.
କେବେ ହେଇଥିଲା?
8/2/2021.
8/2/2021. ତାମାନେ more than 3 years.
More than 3.
Item 43 ରେ ଜଣେ co-accused ଅଛି, but he is from outside. He will claim parity. Item 43 is from West Bengal.
3 years ହେଇଗଲାଣି ଫୋନ କର. 3 years ହେଲାଣି. Earlier he was granted interim bail for 2 months.
Surrender in time. Surrendered in time.
The petitioner is in. What is the status of trial?
Trial my lord on 27/4/22 charges framed. Out of 16 witnesses, 4 witnesses are legend.
The petitioner is in custody since 8/2/2021 in connection with such and such case. It is alleged that the petitioner was traveling in a vehicle in which contraband ganja weighing
128 kg, 300.
128 kgs, 150 grams were being transported.
मैंने अभी पढ़ा नेट वेट 120 300 grams gross हो जी 120 150.
It is submitted that despite being in custody for more than 3 years, trial has not concluded as yet. Sri J.K. Pandal, Learned Counsel for the petitioner, submits that out of 16 charge sheet witnesses, only 4 have been examined so far. The petitioner was also earlier released on interim bail and has surrendered to custody in time without misusing his liberty. The State Council has opposed the prayer for bail by submitting that the quantity of contraband is huge. Considering the submissions and the materials on record, and particularly taking note of the long detention of the petitioner in custody and the slow progress of trial, this court is of the view that I'm inclined to take a lenient view. Let the petitioner be released on such and such each day appearance.
Item 42. The petitioner is in custody, my lord, in 19/9/2021. Lordship consider the co-accused and granted interim bail for a period of 1 year since nearly 3 years he is in custody. He is on the same footing, same.
Your bail application was rejected earlier.
Yes, that also rejected. Both application rejected in one.
Sagardas has implicated you.
Yes. She also same.
Para for
This was granted interim bail.
Interim. Same.
1 month.
Same order.
Yes.
Same order.
Oblige.
Item 43.
Officer 22/27
Yes.
My lord, officer 22/27A of NDPS Act, my lord. And my lord, custody since my lord 9/2/2021, my lord.
Is that same matter?
Yes, my lord. Co-accused, my lord, but he is from West Bengal. That's the difference.
Other accused person, my lord, already released on interim bail, my lord.
Room weekly bail deli para regular bail deli.
Regular bill then जीवरे भी कहली सुन पार ना.
Regular bail deli o kon? West Bengal how about?
My lord.
Release this matter 1 week after.
Item 44.
जाओ किस दिन जाओ देखिए.
Oblige.
Nikhya will have to take a call actually. You see, it is actually becoming, this is injustice in a way, because we are not concluding the trial and we are keeping them in custody for years together. The only problem is that they do not cooperate with the trial. Otherwise, I am willing to grant them bail. The problem is once they go away, and the trial will be stalled. That is the problem.
May I please?
Yes.
खाली 4941 2022 टा हजूर डकैथिले जे आसिले आज ताको ऑर्डर फॉर डिसमिसल कर साला पर एटा को रिवाइव
4941
आज्ञा काली थिला
अच्छा 4941 टा लागलो
सीआरएल फाइल करते अपन डिसमिस कर
on repeated calls the petitioner has also filed another bail application being 3 BLAPL number 3863 of 2024. This matter was earlier dismissed for non-prosecution and has been restored to file
CRL
recently. In spite of such restoration, there is no appearance. The bail application is therefore dismissed. Yes.
restored my lord that से बे restore करके तो dismissal कर देले 3863 टा को डाक्टर नोटा
नहीं कौन
that 4941 against that CRL was filed, that was not restored, I think.
Yesterday it was restored.
Yes.
Yesterday it was restored to file.
मतलब in 3863
कौन सी करी थी ना
43 item थिला 43 नंबर
Tomorrow it was there.
43 नंबर item थिला
restored to 4941 of 2022 is restored to file. So that takes away that. Now what happened?
That my lord, petitioner is in custody. He is a local man, my lord. Custody since 23/8/2021. Running is 3 years. आउ 10-15 दिन अच्छी 3 वर्ष कंप्लीट होगा को क्वांटिटी देयर वर 6 persons in a WB truck 450 kilogram ganja was there. He was sitting on the backside of that dala. Out of 16 charge sheeted witnesses, only 3 has been examined. He has never availed an interim application or not prayed for any interim bail measure. 3 वर्ष हेलानी टोटल अछंदी 11 जण 6 जण स्पॉट रु धरा पड़ले 5 जण बाहर लोक ये जणे लोकल आउ 5 जण धरा पड़ले ड्यूरिंग चार्ज शीट पड़को
6 persons were there, one fled away, that is Manoj Bira.
Se पड़ेला
And one truck along with 2
How many questions have been released on bail?
मतलब मनोज भी रिलीज ହେଇଛି जो रिलीज कर तो से तो बॉर्डर पॉलिटिकल नॉट एन एम्बार्गो
Well, it will grant him interim.
3 वर्ष हो गेलानी
450 kgs.
Yes, man.
Look at the quantity. 450 kg.
He will cooperate with the investor. All लोग at least तारा यही पर.
No.
Bail bond ही पर है. तो he is having मतलब available property is having.
No. You are practicing in the High Court, so you do not know what happens at the ground level.
No, I am also practicing in the lower court as well because I know somehow, but here I cannot say because I want to take the leverage of that, my lord.
No, what leverage? What leverage? You are entitled to bail, you will be granted bail, but this court will also balance the equation. The court will always balance the equation. You have to look at the other side, the prosecution also.
Well, as well as, my lord, in that case, my lord, I must not say anything because like 21 will always override over 37. That I must not say, but still I can.
21 will override. Certainly 21 will override. That is why I am granting you interim bail. In some cases, I know the Supreme Court has said that if if the court wanted to grant him bail, why not regular bail? Why interim bail? Some of my orders have also been set aside, but I stand by my orders. The petitioner is in custody since
23/8/2021.
23/8/2021 in connection with such and such case. The allegation is that the petitioner and several other persons were transporting huge quantity of contraband ganja in a truck when they were apprehended by police. It is submitted that despite being in custody for more than 2.5 years, trial has not concluded as yet. With only how many?
Well, 3 witnesses.
With only 3 out of 16 charge sheet witnesses being examined so far. Stop. It is therefore submitted that the petitioner may at least be released on interim bail in order to attend to his pressing family needs. Learned State Council has opposed the prayer for bail by submitting that the quantity of contraband is huge. Considering the rival submissions, the materials on record, and the fact that the petitioner has been in custody for 2.5 years and and is required to attend to certain pressing family needs, I am inclined to take a lenient view. Let the petitioner be released 4 months. 4 months.
Gotte mas. I can pray for that at least.
What were you praying?
I'm expecting my lord gotte mas बढ़े. Gotte mas. Request.
ମୁଁ 4 ମାସ ଦେଲିନି ଆଜ୍ଞା।
ମୁଁ ସେ ଶୁଣିଲି ଯେ ମୁଁ କହିଲି ହଜୁର
କମେଇ actually 3 ହବା କଥା ମୋ ପାଠ କିନ୍ତୁ ଭୁଲ ବାହାରି ଅଛି।
ଚମହ ଯଦି ହଜୁର ଦେଇଦେବେ ତାହେଲେ
4 ମାସ।
Oblige.
Yes.
Item 45. May I please, Madam, I am not sure.
Where are you, Mr. Patnaik? Nabarangpur?
Yes, sir.
Hello. Yes.
In this case, Madam, the Lordship has granted a bail in bail appeal 1530 of 2023 for 1 month, Madam. And after availing one month bail, Madam, the petitioner surrendered on 14th January 2024. In between, Madam, the last deposition is recorded on 12/12/2023, Madam. Since 12/12/2023 to till date, Madam, no one has examined in this case, Madam. In between, Madam, your Lordship has granted
whatever relief could have been granted has been granted to you. I will not entertain this application, Mr. Patnaik.
Madam.
ଗୋଟେ ଲୋକକୁ ତା ସ୍ତ୍ରୀ ଆଗରେ ଜିଅନ୍ତା ପୋଡିଦେଲା ତଥାପି ମୁଁ 2 ମାସ ବେଲ୍ ଦେଲି ମୁଁ କେମିତି ଦେଲି ମୁଁ ସେ ଭାବୁଛି ବର୍ତ୍ତମାନ
another case is also granted bail.
The bail application stands rejected as I am not inclined to consider the same. See that reject करो rejected.
Madam, may I pray one thing else?
Yes.
Madam, expeditious trial, madam, right? Because 7 months.
You will be showing as your barkate कौन?
7 months वाले गोटे भी साखी है
नहीं कौन होता
expeditious trial.
Out of 11, 9 examined already.
All right. To withdraw them. Learned counsel for the petitioner seeks permission to withdraw the bail application with further prayer to direct the court below to expedite the trial. Permission is granted. Further, the court below is directed to conclude the trial as early as possible. Yes.
Item
46. None appears. Please this matter 1 week after.
Item 47.
47 be same.
I am appealing for the informant.
The petitioner is not there 1 week after.
Item 48.
फाइल आए फॉर मॉडिफिकेशन ऑफ कॉस्ट टाइटल आदर्श नेम टा भूल है सोटा खाली करेक्शन अलियास टा खाली
योर मिस्टेक
नहीं माय लॉर्ड
कोर्ट्स मिस्टेक
नहीं
योर मिस्टेक एडवोकेट यू हैव टू डू इट इन द हैव यू टेकन सर्टिफाइड कॉपी
से मोर कंसर्न एडवोकेट नो से जे अछि बाहर रहि छि मत खाली
ठीक है
खाली कहि छि मत अलियास टा कर देले हे जो पापानाटा
सेटा counsel for the petitioner is permitted to correct the cost title of the bail application in the office. Is to करियो ना ऑफिस रे करियो
46 मिस्टर तारा प्रसाद महापात्र रिक्वेस्टेडमेंट को अर्जन दे मैटर मुझे भूल गई
नो अर्जन कर दी
नॉन अपेरेंस टाइप
ओ नॉन अपेरेंस कर दो
Item 49.
मैं प्लीज that is also cost title PS case number
petitioner is permitted to correct the cost title in office.
Item 50.
The third attempt of the petitioner, before your lordship. The change in circumstances, the husband is already in the order I have submitted before your lordship. And
you are not the husband.
And the cause of death is also finalized. That is poisoning.
Father-in-law and mother-in-law.
They are father.
Last occasion, lordship has directed, but that order has not been complied. Again, they have renewed their prayer. After getting the case diary and
the changed circumstances, I have
CE report, everything was called for. Thereafter, a lordship.
I granted you first hour, second hour.
Yes, madam.
I already granted you.
That why almost a rejection. Therefore,
why rejection? If you want, I mean, if you file a petition for modification, I can modify that order by saying that in the meantime, the husband has been released on bail and that can be considered by.
Objection is made and.
No, সেটা explain কেমন করিবি? আপন সেই application করে খালি modification partition করবো, এই application আপন not press করে দেবে। Let it come next week, so that in the meantime you file a petition for modification. Yes, Mr. Das. This is your matter. Yes. So সেই যে লেখা है যে application সব first hour second hour লেখা है তাদের এই যে changes টা add করে দিলে না আপন। That will be suffice for you to be granted bail.
The same thing can also be done in this.
No, how
If you lordship wishes, I am not.
No, Mr. Purohit, I think this will be technically wrong. I mean, you are so vastly experienced, I don't think you have more knowledge, but this is another fresh application. This application, a particular order has been passed, it has not been complied with by the petitioner. Over and above that, I cannot pass another order, I believe. I don't think.
But for the supervening circumstances only.
No, it's all right. The supervening circumstances, you incorporate it in your modification application. That will be considered, I will do it.
I will do it.
And this you will withdraw it. List this matter next week. That's all. Simply. You file that petition and get it listed.
Item 51.
Item 49. Course of day. 49. And that order in course of day may be given that order.
What?
49 modification.
Modification of course of the day.
In course of day can be given correction.
Oh, according to the offices, all right. In course of the day.
My lord, co-accused granted bail by your lordship. Same order.
Verified, my lord, similar footing. Earlier order in ABLPL 167.
Kanun Choran Malana?
Yes.
All right. Same order.
So item number 6.
It is transfer of CP mark from the court of Family Court Jaipur to the Learned Family Court Malkangiri. On the ground of disability, Annexure 2 have filed. This is 55% disabled and is could not able to move by bus, my lord.
All right. Issue notice to the opposite party by speed post. Fixing a short returnable date. Requisites be filed within 3 working days. List this matter.
September, sir.
September. 12th September.
My lord, IA is there 187. IA number is 187.
Yes, see.
Nahi, aji filing korchi. Today I have filed IA. That's it. Feeling.
Asini ayota asini kon kore jao.
My number is 187.
তাহলে সেটা এইটা গোটা কাম করে এটা নেক্সট উইক নিয়ে এসো along with the IA so that this order can be passed.
That's Monday.
List this matter next week along with IA number
187.
187 of 2024. আর ওরা কাটবে তো সেই দিন সেটা এই নোটিশটা করে দেবো একাত্রে তারপরে
So item number 32.
May pick here the petition of the wife seeking transfer of the case from
Yes,
the
Mr. Mansi.
Petition of the wife, lordship.
Notice was issued.
Notice was made sufficient on 7/5/2024. That on that order reflected that notice is served recently.
So wanted to give opportunity to them.
And on 25th it is third occasion, lordship.
All right, we'll display. You wanted from Khalikot to Aska?
Aska.
All right. Khalikot to Aska कितना बाटा
नहीं सी तो remote area रे Khalikot to Aska होच 50 किलोमीटर किंतु petition रो गांटा गोटी remote part Aska रो 30 किलोमीटर दूर पड़े.
The petitioner seeks transfer of MAT case number 17 of 2023 pending in the court of Learned Civil Judge Senior Division Khalikot to the court of Learned Civil Judge Senior Division Aska. It is submitted that the petitioner is residing in a remote village which is at a distance of more than 80 kilometers from Khalikot. Further, she does not have adequate financial wherewithal, financial support to travel to Khalikot on the date of posting of the case. Despite sufficient notice and repeated and multiple opportunities, the opposite party husband has not appeared. Considering the submissions and the grounds raised, I am inclined to allow this. I am inclined to accept the same. The transfer application is therefore allowed. The transfer order. It is directed that such cases, will. Yes.
So right now 35. Matter was passed over. Petitioner was not there.
What to do?
They have got this stage. And in fact, last occasion, if your lordship may see the last order, I filed a 340 petition that they have submitted certain facts which is incorrect and foreign to the present case. Copy was also served. Your lordship.
Then I'll record that there is no appearance. I'll keep it to next week. That is the only thing that can be done. And there's an interim order in this favor that will probably for 1 week at least allow it to continue. Thereafter,
No, on that I have nothing to say. But 340, my lord, your lordship should take a view on that. 340, I have filed that they have given certain wrong facts before your lordship on oath.
probably has it been served upon them?
Yes, my lord, may kindly see the last order passed by your.
Yes, yes, I've seen. That is why probably they are not appearing. Good opportunity देगी देखिए.
As your lordship.
None appears for the petitioner on repeated calls. Sri A.P. Bose, Learned Counsel for the opposite party, is present and wants to press the IA filed by him under section 340 of CRPC.
127 of 24.
This court, however, deems it proper to grant one more opportunity to the petitioner to appear. Release this matter next week. Interim order to continue. Sarila. କୋଉଠୁ ଯାଇଥିଲା ସେଇଠୁ କରିଥିଲେ
Weekly list item number 42.
Your matter, Mr. Manathi. Next week. Yes.
93 would pass over the line.
How color?
Item number 45.
45 is also yours. Next week.
Next week. 29th July.
29 July. We commencing 29 July.
Item number
2007 matter, Mr. Manathi.
Yes, I am doing 29th, 30, 31st. I may not be there. Some function in the family. First week of August, any.
So we commencing 5th August.
We commencing 5th August. All right.
Item number 46.
My lord, item number 46 kindly be taken up some other day.
46 of Guardian Koro.
So we commencing 12th August.
12th August. Yes.
Item number 48.
And for the respondent.
Yes.
My lord, seek an adjournment.
Yes.
My lord, seek an adjournment in this matter.
I oppose, my lord. As the last man to oppose, because with due respect to my lord, senior my lord, the last lordship kindly see the order dated 5/7, 5/7, 11/7 and 15/7. The last order also.
Yeah, order sheet पूरा नहीं.
Last chance peremptory therapy.
Come. If there is any difficulty, we will see. Start. If there is any difficulty, don't worry. I will not close it today. Let it begin. Let it be part of it. Yes.
My lord, senior was supposed to argue this matter.
Seven बेल का emergency matter absent है वाला.
ମୁଁ କଣ କରିବି? Absent ତ ମୁଁ ନଥିଲି, ମୁଁ ତ ଥିଲି present.
ଆସିପାରିଲିନି ବାଟରେ କୁଟର ତେଲ କରଲା ଟିକେ ପୁଣି ଗଡି
ସେଥିରେ ବି ମୋର ଭୁଲ ନାହିଁ ଆଜ୍ଞା.
ନାଇଁ ମୋର ଭୁଲ ନାହିଁ
ସେଥିରେ ବି ମୋର ଭୁଲ ନାହିଁ.
ତାର ଏଣ୍ଟ୍ରି ବଡ କଣ୍ଟିନ୍ୟୁ ହେଇଯିବ.
हाँ सेटा केबे रखियो 47 हां गोटे डेट कर दियो नॉन अपेक्स टा काट दियो गोटे डेट कर दियो मैं डेट करी की एंट्री मॉडल को कंटिन्यू कर 9th August entry model will continue.
We are against a reversing judgment over here. We were defendants in the court below. The appellant had filed a suit for declaration of right at.
What is the substantial question of law? Let us see.
There is a requirement of.
Yes, this is for admission.
No,
This is a hearing.
Hearing.
Substantial question of law kahin?
Already framed. Order number 23.
Order number?
Order number 23, order dated 6/11/2023.
This is a requirement of framing of additional substantial question of law. The learned trial court had dismissed the suit, and the learned appellate court has decreed the suit. Lordship, there is a requirement of framing of additional substantial question of law. Why I say is that there is a finding by the learned trial court that possession was never handed over to the plaintiff at the time, where the plaintiff has himself admitted that at the time of purchase he had found us in possession and he had allowed junction. Plaintiff's case is that the property originally belonged to Dhanu Sahu and Kalu Sahu. Dhanu Sahu and Kalu Sahu alienated 10,000 square feet of the land to one Brajavasi Bedbu. Brajavasi Bedbak, they alienated 6,000 square feet, and to Mitradev Nanda, they alienated 4,000 square feet. Now, it is the case of the plaintiff that Brajavasi Bedbak in the year 1955 has alienated that suit property entire out of 6,000 square feet. He has alienated 4,000 square feet, which is around 0.89 decimal to one Dibakar Mishra. Dibakar Mishra's son, Biswanath Manoranjan, and his grandson, Somnath, have alienated this property and to the plaintiff in the year 2002. And that is how, in the year 2002, which is the sale deed is at Exhibit 6. The case of the plaintiff is that that is defendant number 1 and 2, were tenants who were inducted by Dibakar. And because of sympathetic ground, he allowed us to continue as the tenant of that particular suit land. And on the occasion of asking us to evict and go away from the suit land, we refused, which is why he has filed this civil suit. Now, the case of the defendant is that the mother of our mother had purchased this suit property from one Harihar Das, who happens to be the father of defendant number 3. Defendant number 3 purchased this particular suit property from Brajavasi Bedbak. It is the admitted case that the encroached portion accounts for the 0.89%. And we have encroached that, and it was well within the knowledge of Dibakar Mishra. And the fact pleaded by the plaintiff that we were inducted as tenants by Dibakar Mishra has not been corroborated by any any lease agreement, any rent receipt, and not corroborated by any evidence. Now, it is seen the learned trial court has given a finding that at the time of issuance of ROR in favor of the plaintiff, the ROR says that there is a house standing over the suit land. But if your lordship will go into the recital of these sale deeds, your lordship will say the description of the suit land is that of a Mela deer. And there is a ambiguity with regards to whether there was a presence of the suit house, whether there was a presence of the house over the suit property at the time of purchase, and if so, who has constructed the house. And the plaintiff has not been able to say exactly the holding tax paid by him, neither is being able to say as to neither is being able has been able to prove that he had constructed the suit house. The ROR has been issued 4 months after the execution of the sale deed. It is impossible for the plaintiff to raise a two-storied building in the span of 4 months. So what needs to be in the trial court, in the appellate court, has gone on to hold that the burden of adverse possession has been completely shifted to the plaintiff, which should not have been done, and that the ROR recorded in the name of Dibakar, there was dwelling house prior to the purchase of the plaintiff. Hence, it is proved that the house belonged to Dibakar, and it is not.
Is the recital of the sale deed, is it ambiguous?
Recital of the sale deed, Lordship, may have a glance at the sale deed.
Yes. Also, you have a copy.
I have a copy. Exhibit 6.
ये किसी पढ़ो
Third page.
पढ़िया भारी कष्ट ये करणी अक्षर उल्टा विव्रत कौन विकृत भूमि घर बारी किसम थिले हैं कौन पढ़ी पारछन आपण कैन यू रीड इट आई डोंट थिंक शी कैन रीड इट वेरी डिफिकल्ट कौन पढ़ी ये करणी अक्षर एटा छोटा है कि आगे देखी हाँ मेला डीह अटे चौहदी उत्तर की दर्जी गोटे प्रेमा दर्जी दक्षिण रास्ता पूर्व निरंजन साहू पश्चिम ब्रजवासी कौन गोटे तो मेला डीह
But ROR
व्हाट इज द मीनिंग ऑफ मेला डीह
open vacant land.
Vacant homestead for डीह माने डीह लागिला माने होमस्टेड हेगला हैला पूरा माने फैलो लैंड नुए
मेला खाली
माने खाली किछि तयारी नि ता माने तादर किछि थिबो ता तळे माने तयारी हेतिबा बा गोटे हाफ कंस्ट्रक्टेड हाउस बा हाफ कंस्ट्रक्टेड घरर बंध बंध टाइप रो थिबो ये मिस्टर बाग व्हाट वुड बी द इंटरप्रिटेशन ऑफ डीह डीह माने तो होमस्टेड नुए की
यस
घर बोली कहबोनी किंतु ए जो घर तयारी
homestead without any construction.
Without any construction.
Yes.
But identified as a homestead land.
Yes, homestead.
But they say that there was a house on it.
There is a house, and the ROR, which is at annexure, which is at Exhibit 8. Exhibit 8 is there is a mention of a house present, and that ROR has been published of 4 months.
House may have been constructed later on, subsequently.
In 4 months, Lordship, how will the house be constructed?
Na kon ye is it a concrete house?
It's a concrete house.
Okay.
Also, another finding of the learned trial court is that I'm relying upon the trial court's order because this finding has never been challenged. These findings have not been challenged. Neither has the learned appellate court given any opinion or observed or given any care to that particular finding or even overturned that finding. The Exhibit 1, which is the salary certificate of the petitioner, plaintiff. Salary certificate says that the plaintiff's annual income is of 12,000 rupees. He's a beetle shop owner. The suit property, as per this particular sale deed, the suit property this sale deed has been executed for a consideration of 68,000 rupees. He did not even have the capacity to enter to purchase this particular suit property, which has also been given as a finding by the learned trial court. Now, in view of these two findings, substantial question of law needs to be again added.
You were supposed to file a memo.
Memo.
I
have
a memo is not on record.
No, it's not.
What is your preliminary reply, Mr. Tripathi?
Two questions arise relating to adverse possession. In one hand, they are accepting my title and in other hand, they are disputing my title and claiming adverse possession. In that WS, they are saying Dibakar Mishra was not the owner of the land. We are the adjacent land purchaser, and after purchasing the adjacent land, we constructed our house on the adjacent land, our purchased land, and we encroached upon that portion of land, and Dibakar Mishra was not the owner of the land. But in the written statement, they also admit, yes, Dibakar Mishra was the owner of the land and we claim adverse possession. Both the things cannot go together, Miller. And second thing is
very contradictory.
Contradictory. The second thing is that, Miller, Law and Trial Court has held, though the defendant is pleading adverse possession, it is the duty of the plaintiff to prove that he is not having adverse possession. This is contrary to law. So far, this Meladiho is concerned, Miller, what my learned friend was submitting. PW3, that is a son of Somanath Dibakar Mishra, he has stated in that evidence that due for the purpose of court fee, Miller, we stated in the RR that is a Meladiho, but the house was constructed there.
Oh, Mr.
That is there.
Is a direct bar, 92 is a bar. Or a Meladiho लिखना था, तब कौन है हमें गौरव थिला, हमारे कोर्ट फी पड़े बोले हमें Meladiho लिखी. You admit that?
Only two things, Miller, here. In the one hand,
so that is to the Juta Apa Coil simultaneously they're making two contradictory pleas that will be examined. Well, do you have that memo?
I'm not sure, but it has been filed on 12th August 2014.
No, you're right. Okay. Why do we need to frame this? The defendant by a flux of time has perfected title by adverse possession. When see you happen whether the title could whether subsequent trial court of Orissa. We can take up the additional point number 2. There was a order I filed, but probably that has not been acted upon. Produce the memo filed by the appellants. After hearing learned counsel for the appellant and on consideration of the issues involved in the appeal, the following additional substantial question of law is framed. It is a memo. The memo serial number 2. Serial number 2 will suffice. That will cover everything. Third in part. Let's this matter next week. Let's this matter next week. We'll continue.
Interim order may be continued.
What interim order is that?
Stay of execution.
Execution proceeding is going on.
Already deliver position of given to me, but execution proceeding last part is state.
Achha. Where is the IA?
I have filed a IA for vacation of state order.
अरे तो सुनिए आरो वीक रे कौन आरो वीक रे सुनिए हाउस टाइप है नहीं यस आइटम नंबर 50 हाउ 50 जाए you have put in your matter Mr. Bhag is a hearing matter.
No, admission.
I'll take up just खाली मैं गड़े दूँ से
October 6th your lordship.
हाँ no
The lordship, it may be taken up next week.
all right next week as per for 9 July 29 July
Item 51.
Your lordship, my lord, I am appearing on behalf of Miss Sailawala Jana. My lord, we have entered appearance. 1 week may be granted. My lord, our name may be reflected on it.
You what is the name of your senior?
Sailawala Jana.
What is your name?
Kirtiraj Nanda, my lord.
Kirtiraj Nanda.
Yes.
Sri Kirtiraj Nanda appears and submits that Ms. Sailawala Jana, advocate and associates, have appeared for the appellant and request for an adjournment. List this matter for August.
In the week commencing 2nd September.
In the week commencing 2nd September, indicating the names of Mr. and Ms. Jana.
Item 52.
May I please yours. But I pray for a short adjournment, Your Lordship. The reasoning Mr. Mishra was to conduct this matter. There is a appeal preferred by the state, the Rahama Hatta matter. Due to some personal difficulty, he had to leave for home.
Yes, what do you say?
Lordship, only short adjournment was given, he has taken a lot of adjournment.
Get ready for, you will argue the matter. Huh? Get ready. All of Mr. Mishra's matters are being argued by his juniors because every time the matter is listed, the same submission is being made. So get ready. List this matter.
12th August.
12th August. Yes.
See, interim order is there.
What interim order is there? Interim order is already passed.
Yes, Your Lordship.
Then it will continue.
7/2/2020.
Interim order to continue.
Public.
Item 53.
Lordship, on behalf of Mr. Ekipana, Lordship, the matter may be taken after a week, Your Lordship.
Yes, Mr. Mahapatra.
In this case, I have filed an application for extension of status quo order. Lordship, have a look at the order dated 24th.
Your IU is 226 of 2023.
Again.
No. The status quo order was passed.
Then that was also extended on 31/8/2023.
Will extend it or?
Yes, again.
List this matter. As played for, list this matter on
2nd September.
2nd September. Week commencing 2nd September. Interim order dated 24th March 2023 shall continue till the next week.
Item 54.
This second appeal has a very short point. The question of law was formulated on 1/5/2024. And I'll just apprise my lords.
My lord, I am not feeling well today. May I pray? In fact, I came seeing this list.
That section 14 thing.
They will
covered by a judgment of the Supreme Court.
No, I was just too many times. So far the law is concerned, I don't have no objection, but
I think it has to be remanded then. It has to be remanded back to the.
It has to be remanded back to the first appellate court to hear it on merits.
No, but since Mr. Barik is asking for time, I will grant you a very short adjournment.
I will grant, yes, my lord. I will grant, I will
next week.
bless the facts. Yes.
Next week. No, but if the law is clear.
So far, but the law has to be applied in a facts and
Certainly.
My first appeal, all that I pray, my lord, my first appeal has to be heard on merits, which the first appellate court hasn't done.
My lord,
it so happened that you file a civil revision or
we filed a civil suit.
No, may I clarify the facts within 2 minutes? Next
point I is simple. Page 18 or 20, the lower appellate court says that section 14 en bloc cannot be applicable to appeals. There are two direct Supreme Court judgments on this point.
That observation is incorrect. I accept that. But besides that, other facts are to be stated before your lordships. Because here what has happened, the suit was filed against the father. It was decreed. Thereafter, the son filed a suit challenging that very decree as the next friend of the father, saying that my father was unsound mind. The father appeared in this case, filed an affidavit saying that no, I was never unsound. And when the matter was pending, the father expired. Now the son substituted himself. The matter was continued for 10 years and the decree was, his suit was dismissed. Against that, he has already filed an appeal. The appeal has already been also admitted. Now he wants to challenge the very 2008 judgment again.
We'll see.
Yes.
All right.
Whether due diligence and bona fide.
This matter next week, as paid for by Sri P.R. Barik. 29 July. No, 29, the week commencing 29 July.
Item 55.
Hey, 2024 matter. I am interested to grant time. Is this matter?
We come to 9th September.
9 September.
Interim order is there.
Interim order to continue.
So the first
Password rakhi de. Password first to nije padega. People are waiting, so.
password item number 4.
Pore ki season abhi kya appear karo na?
Friday over plus Friday.
Item number 4. On behalf of everybody, please adjourn.
You had specifically asked for the matter to be taken up on Friday.
Non-sir cannot come, so next week, please adjourn.
Mr. Rao, this is your matter. Item 4. Of course, this has come for orders. Substitution matter. Substitution achhi apna kichh kare. As requested, list this matter. As requested by the counsel of the petitioner, list this matter. Kya kar diya? Week commencing 5th August. Tapare?
Password item number 6.
My lord, in item 6, my lord, I had submitted that the respondent number 1 has no heir, but there is a difficulty because she was the plaintiff in the court below. How it is to be prosecuted, my lord, I will assist your lordship. Your lordship may kindly take up next week around, on Friday, because that is necessary. Because legal point is involved, I have to assist your lordship.
This is matter next week as per for. Week commencing 29 July.
Next week,
29 July. Next week, it will 29 July.
As your lordship, please.
Yes.
Item number 24.
Here I am for the respondent.
This is admission.
No, this is for order.
No, item 24 is for admission.
Order. Order.
Item 24.
496.
Week sara bhi
Appellant ke naam.
2018 matter.
Suit for partition.
But the appellant is not there.
That's right.
None appears for the appellant on repeated calls. The matter being in the weekly list has been called out every day. That is on Monday. Monday to nakhela sir chutti thila bata.
Monday.
It is on no Monday to thila nahi. That is on 15th, 16th, 18th, and today that is 19th. There is no appearance. Learned senior counsel appearing for the opposite for the respondents is present. For the ends of justice, one more opportunity is granted to the petitioner to appear. Let's just matter next week. Get next week karo, huh?
So 22nd.
22nd July. Yes. Tapare?
Item number 32.
32.
Please, your lordship. Lord, a reversing judgment. The suit was filed by the father of the respondent, seeking a relief of perpetual injunction. The claim is that the MS Khata number 199 was recorded in the name of Raja Sholendra Narayan Bhanjado. In the remark column of the plot, there is a note of possession in his favor. He claimed that since it was a Potadari Khata, there was difficulty in obtaining Khasmal permission. It was a Khasmal land with a Potadari status in favor of the erstwhile King Miller. So he executed an agreement on 20 September 72 for purchase, and accordingly a registered agreement for sale was executed in between the landholder, that is the Raja, and himself, and he took delivery possession, consequent of which his name has been reflected in the remark column with note of possession, though the khata was prepared in the name of the intermediary. He filed the suit that he is in possession, that I am trying to dispossess him and interfering in his possession. I filed my written statement. In the written statement, I have taken this specifically that the shared agreement dated 20th September 72 is not in respect of the suit land. It is in respect of another civic plot whose corresponding plot has been recorded in his favor, but the remark column note of possession is an erroneous one. In fact, the intermediary has entered into an agreement with me in the year 2013, a registered deed of agreement for sale and delivered possession. I am in possession. There are 4 shop rooms constructed by me. It has been tenanted in favor of different persons. The suit was dismissed after detailed discussion. Your Lordship may kindly see the findings. Page trial court findings, Miller, at paragraph 7, page 40, running page 40.
Yes.
Hence, the suit is barred for non-gender of necessary parties, since the Potadar was not implicated as a party. Then the most vital finding thereafter, Miller, page 41. Plaintiff was examined, one of the plaintiff was examined as PW5. There the court has taken line number 3, Miller. The plaintiffs in this case have failed to prove the above registered agreement bearing number 135 dated 14 September 72. The plaintiff has not filed that document. I have exhibited that document to show that it not in respect of the suit land. Again, PW5, who has given her evidence on behalf of all the plaintiffs, have admitted in her cross-examination that she cannot say anything about the plaint or about the document which her father had filed, and that she cannot say about the contents of the plaint. She had again expressed inability to say the CS khata number or CS plot number of the suit land. She again stated her father had purchased land from Kanika Raja, but she cannot say the deed number or the plot number by which her father purchased in the year 1972. She again stated she cannot say about the registered deed of agreement bearing number 135, which is mentioned in her plaint. In her cross-examination, she also admitted that the defendant is in possession of the suit land purchased by the registered deed executed by Jyotindra Narayana Bhanjadev. Again, she stated that the defendant is possessing the land of Ajit Bangali. Being suggested, she again admitted that the defendant is residing on the suit land, constructing one house on it. Plaintiffs have relied on decision number so and so. Now, your Lordship may kindly see, in a suit for perpetual injunction simple sitter, the title is disputed. Admittedly, nobody derived title. It is through only agreement for possession, registered agreement for sale, parted with possession, Miller. There, the learned trial court, considering everything, recorded a conclusion that since the admission of the plaintiff that the defendant is in possession, the plaintiff suit is liable to dismiss in absence of recovery position or declaration following the dictum of apex court in Anathola Sudhakar Mill, P. Buchi Babu. An appeal was carried by the plaintiff against that judgment. The learned appellate court, in a misconception of fact and law, held that the suit is liable to be decreed only on the finding. Your Lordship may kindly turn to page 26, paragraph 20. 21, your Lordship may kindly, paragraph 20, last 6 lines. The defendant has only proved the document, registered agreement to sell by the exhibit E, showing his possession. He further relied on the document of agreement to sale of plaintiff had document number 13572 of 1972 dated 2972 marked exhibit A. He also relied on the mutation error marked as exhibit B, plot index marked as exhibit C and D. the learned counsel for the defendant, respondent, or that plot index, that is exhibit C and D, corresponds to plot of MSROR.
All right. I think the substantial questions.
Substantial question of law I framed me out. That your lordship will get.
C will do.
Miller.
C has to be. C will cover everything. Now faster darkar.
Faster darkar.
AOC kar
deba.
Heard Sri Vivekananda Bhuya, learned counsel for the appellant, peruse the impugned judgments, considering the submissions and the grounds raised. The second appeal is admitted on the following substantial questions of law. A or C, page 10, right? Page 10 of the appeal. A or C. Issue notice to the respondents by registered post with AD fixing returnable within 4 weeks. Requisites be filed within 3 working days. Place this matter September. In the week commencing 23rd September. Call for the LCR. That's all.
I have filed an IA to protect my possession.
IA 749 of 2024, right? Notice as above, considering the submissions. Status quo as on date in relation to the suit property shall be maintained till the next date. Yes.
Item 33.
You have probably appeared through caveat.
Miller.
You were admission of a
May I please, your lordship? Confirming judgment. The plaintiffs are with your lordship.
Yes.
The plaintiffs filed the suit for partition and for declaration that the alleged gift deed executed by defendant number 4 in favor of her daughter defendant number 1 is void, and by the said deed the right that interest and possession of the plaintiffs and performed nor affected, and permanent injunction. The suit was dismissed on completely on technical ground, section 51 of the Consolidation Act and other provisions. And the sale deed in favor of our father was not believed because it was certified copy, exhibit 5. Then I filed appeal. Appeal is also dismissed, but exhibit 5, the sale deed was admitted in evidence. Now I have prepared a short chart. It came out. Okay. My lord, Harivar Mishra was the owner of the Scotland, exhibit 4. As persons, namely Biranchinaran Mishra, respond number 2, defend number 2, and Rabindranath Mishra, respond number 3, defend number 3, and one daughter, namely Bobita Satpathy, the respond number 1, defend number 1. Then 2011, exhibit 9. After death of Vaidyanath Mishra, his wife Padmavati Mishra alone executed registered gift in respect of the Scotland in favor of her daughter Bobita Satpathy, defend number 1. Exhibit 4 is the ROR. Then exhibit 6 is the certified copy of the information sheet. Exhibit 7 is the correlation, consolidation and her ROR. Now question is, both these should have been, both the courts have dismissed the claim of the plaintiffs. Now question remains, my lord, when the consolidation ROR was published prior to, my lord, the gift deed, alleged gift deed, or sometimes in 87 was published. By then, homestead land was not included within the jurisdiction of the consolidation authorities. By amending Act dated 16/3/1989, it came into with retrospective effect, with effect from 10/8/1973. But by then, ROR was completed. Proceeding was completed. So law says,
was there no saving clause?
I'm abstract, yes. But in the same there was no saving clause, but interpretation has been made by this honorable court and division bench also that proceeding which is completed, that will not be applicable. For that, your lordship may kindly see.
Completed proceeding will not be reopened.
Reopened.
ଟିକେ ବାବୁ ଆଜ୍ଞା ଖାଲି ପ୍ଲାସିଟମ ଟା ଆପଣଙ୍କୁ ଦେଖେଇଛି ନେକ୍ସଟ ପେଜ ଆଜ୍ଞା କ୍ଲାସ ନମ୍ବର 2 Orissa Consortium Holding and Prevention Fragmentation 1972 section 3 homestead. By the time the dispute was being tried by the authorities, homestead was not covered under the consolidation scheme. The amendment came in 1989. Any decision previous to amendment rejecting the prayer under the act regarding homestead is valid. Then another decision, if you lordship want to see, 1992 Weller vis-a-vis 51 section 51 my lord, first my lord. Consolidation holding prevention section 51 having regard to the nature of the case, if consolidation had no jurisdiction to entertain the claim, the decision of the authority would be a nullity and is not a bar for exercise of jurisdiction by the civil court. So my submission is, when the ROR was published, the homestead land was not included in the act giving jurisdiction to the consolidation authorities. So section 51 will not come as a bar. But the trial court as well as the first appellate court held that section 51 is a bar. Furthermore, your lordship may kindly see for a moment page. I am giving the certified copy of the plaint. One of the ground of the appellate court is that I have not prayed for declaration right title interest. Paragraph 14, your lordship may kindly see the plaint. Yes. B. Let a declaration be made that the registered deed, gift deed, bearing number such and such, dated such and such, being a void deed, no way affect the right, title, interest, and possession of the plaintiff, and defendant 5 to 8 over the suitland in any manner. Then 1 is for partition, 1/3 by the plaintiff, and the rest by the pro forma defendants. So my submission is, now I will take one by one to the finding of the first appellate court. 33, your lordship may kindly turn to page 33 of the first appellate court judgment. I have marked 33, my page 33. Yes. Again, first, just before paragraph 15, in spite of asking for the right, title, interest over the suitland, the appellant seek partition over the suitland, which is not, it is complaint error of record. I have shown your lordship to the prayer B. Then next is, trial court has rejected my application suit on the ground that our purchase, on the ground that exhibit 5, the certified copy of the sale deed by our father is not acceptable in law. That has been accepted. Your lordship may kindly turn to my lord, page 27. Page 27. Your lordship got it, madam. Just before 13:1. In view of the above discussion, yes, I am of the opinion that the contents of certified copy of the registered sale deed, exhibit 5, as well as its execution is duly proved by the appellants. So, the registered gift deed by Baidyanath Mishra in favor of our father is held to be valid. So, by the time consolidation operation completed with final publication, Baidyanath Mishra had no interest, right title interest over the property. And when consolidation authority has no jurisdiction to decide it, it is deemed to be published under the Service Settlement Act. So my submission is, the gift deed, registered gift deed by the exhibit 9,
only by the wife when there are other three siblings of Vaidyanath Mishra is completely void because there is no right, the donor has no absolute right over the land because her husband has alienated it by registered sale deed by Exhibit 5. That has been negatived, my lord. And the finding is, further finding is that because we have prayed for partition, further finding is that partition is not maintainable because they have failed to prove ancestral property. It was purchased by our father. We have inherited it. Plaintiff and profound independent. So that finding is also wrong. And further section 51, appellate court, trial court, 57, 1 is a bar. My lord, suppose assuming 51 is a bar, my lord. Assuming, my lord. But because, my lord, section 34 and 35, now the act has been amended.
36A
again.
36A.
So my submission.
Today I will pronounce a judgment on 36A.
So it was maintainable, and I have already framed the substantial question of law. Your lordship may kindly see.
I think
page 8 onwards.
See.
Article 35 is relating to Chocoland. It has got no nexus, no non-consolidable land. Here, admittedly, it is a non-consolidable land. Admittedly, ଆପଣ 36A କହିଲେ ନା 36A ସହିତ କିଛି ସମ୍ପର୍କ ନାହିଁ
ଠିକ ଅଛି ଠିକ ଅଛି
36A ର only Chocoland ପାଇଁ fragmentation of consolidation.
So I think we can admit it on this
A minor substantial
A and B. A, B and D.
D na D आगे आंसर है जे मु भूल लिखि दै सेटा फर्स्ट appellate court कहि दै छन एटा
okay
admissible मु दउ छै आगे substantial additional टा दरकार नहीं
A will be there. A and B
ना A B न हो
B टा होनी
दउ छै आगे तो देवी बोले रहो दउ छै
By that time, her husband had already alienated the property.
Yes, yes.
So these two.
Again, एकटा वे दुईटा.
All right.
दुईटा देखो jointly again.
Third Sri consider back. Learned counsel appearing for the appellant. Produce the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Setru anime page 8 to anime A. It a BC कर दो, है ना?
I have filed an IF for injunction.
Yes. Since you are appearing for all the respondent.
I am appearing for Babita Satpathy.
Only.
Again.
Only she is the contestant.
So
I have notice to all, my lord.
Let him take notice. But you are appearing for respondent number 1.
Number 1. Different number.
No notice need be issued to respondent number 1 as she has entered appearance through caveat being represented by Sri Vivekananda Bhuya. Let a copy of the appeal memo be served upon her. A copy of the appeal memo has already been served. Issue notice to respondent numbers 2 to 8. 2 to she to kono America achi mote majire. America what achi?
आगे 3टा अमेरिका
3टा अमेरिका
आगे
तांकर ये कोन करिवे
कोन करिवे
एठी नेबी अमेरिका कोन एड्रेस जदी मिलिबो देबी नचत नै
अपन देजन अमेरिका एड्रेस
सेही एड्रेस कोन अमेरिका गोटे दिन रहंती गोटे जगह रे
नहीं
नेबी आगा नेला परे देखिबी जा
अच्छा हो returnable within 4 weeks except respondent number 3.
Okay.
For whom the notice shall be made returnable within 8 weeks. Requisites be filed within a week. Call for the LCR. Well, I'll list this matter.
30th September.
October. 8 weeks again. We must put LCR.
The week commencing 21st October.
Week commencing 21st October. What IU you have filed?
IA for injunction, my lord. There is a shop room where I have a medicine shop. Now, after this order, your lordship may kindly see for a moment. Take a deal.
There I have objection.
Yes, I will.
I got it. Another suit.
Again,
there are 2 suits, my lord. One filed by him. This was dismissed. another suit filed by me against his brother, who is admittedly his brother. He was a tenant. He admitted my ownership. He continued as a tenant. He was paying rent. Because of filing of the suit, he did not pay the rent, my lord. I filed the suit for eviction. Now I got a decree for eviction, also realization of the area rent, my lord. Now my lord, in fact, intend to stall that decree, my lord, through the process of this case, my lord.
No, but if he is in possession,
He is but is subject to payment of decretal dues, my lord.
So-
He is in possession as a tenant.
But here I
Able to
file the
suit, my lord, your lordship knows in a suit for landlord and tenant, the
Yes,
apex court is clear, my lord. I filed the suit for ejectment, got a decree for a decree of eviction as well as for violation of the rent, arrear as well as current.
that has not been challenged.
That has not been challenged as yet. That has been confirmed in
Well,
appeal.
that is not the subject matter here, my lord.
No, subject matter is same.
What is
Suit
that?
property is same.
No. Property may be same.
Yes.
But in this
This is a medicine shop
shop.
being run by you.
Yes.
And you are a tenant.
No,
His brother.
not tenant.
His brother.
Now, what has happened, my lord, real fact, we the brothers are not pulling with each other. And the other brothers, just to dispossess me, join hands with the defendant number one. And they have started the collusive suit there. But here I am claiming my independent right by virtue of the purchase of my father.
You will simply say status quo be maintained.
Yes, my lord.
Status quo, my lord, that means protecting the possession of tenant, my lord.
Yes, certainly that eviction does not relate to this particular.
This particular property, my lord. This particular.
Then you let us argue. You argue the matter. Show me the correlation between this property and the other.
Same property, my lord. A decree, I can file.
Yes, file the decree. We'll see.
In both these.
I'll take it up on Monday. This.
Yes.
So for I will take it up on Monday.
Yes.
Till then one start, my lord already ଅଧା ଭାଙ୍ଗି ଦେଇ ସାରିଲାଣି ମୁଁ ଜରି ପକେଇକି ତା ଉପରେ ରହିଛି so that medicine ନଷ୍ଟ ହେଇପାରିବ ବୋଲି
No, Monday ଆପଣ ଯଦି if you want to, you have to show me the correlation.
My lord, only the decree will suffice, my lord. Your lordship will, from the decree it is apparent the properties is the self.
So we cannot be dispossessed now. Well,
No, I don't want to dispossess your lordship. May record my undertaking, call it on Monday so that I can file the decree to satisfy your lordship, my lord. I got the decree in respect of the self.
No, now that I have admitted the appeal and I have fixed a date for hearing. He cannot be dispossessed in the meantime. Subject to whatever you say, subject to he may deposit
the decree, my lord.
No, he will. If at all he is to make any payment, he will make the payment to the court without prejudice.
Right.
Without prejudice.
Make the deposit.
Not on this, I do not know whether any appeal has been filed against that or not. I do not know. I have no. But on this record,
both the cases tried one after another. Both the appeal decided on the same day one after another.
It is a second appeal. Out of record, nothing can be done. I have he has lodged a caveat sufficiently ahead. I have filed served the copy. On this record,
his brother.
No, one thing is very clear. His possession should not be disturbed insofar as this appeal.
He is in possession, but the possession is of that of the respondent number 6 and 7.
Well, so let us comment and everything will suffice.
Miller, that means protecting his possession without satisfactory.
Status quo would be maintained.
With regard to possession.
Already you make some deposit in the court.
Yes.
Make some deposit without prejudice.
Why deposit? Here nothing is about money. Nothing. My suit is for partition, declaration and permanent injunction. I have claimed independent title, not as a tenant.
Then let us see the other decree. I'll call it on Monday.
Right.
Only the IA will call it on Monday.
Right.
IA will look this matter on Monday for orders. Till such time, status quo shall be maintained.
Right.
Second appeal ଯେତେବେଳେ ଆସିବ ସାଙ୍ଗରେ ଆସିବ କିନ୍ତୁ ଆଇଏଟା କଲା ଆଉ ନାହିଁ ଆଉ କଣ କୋଉଟା ରହିଲା
Item 34.
Anybody 34
Next week.
Obliged.
Item number 38.
38 चलो और मोहरम गुड़ा था See, the quota My pattern worship item 49 टा PS केस नो एंटर सेटा कॉपी पेस्ट ହେଇଛି ସେ cost title paragraph ଟା PS केस GR केस PS केस GR केस and PS number ना Obligers